Gujarat, how many matters do we have?
My lords, I believe there are 3 matters. I am appearing in Kirti Agarwal and others versus High Court of Gujarat, which is writ petition number 1.
Just one, sir.
There are 2 other petitions from the Gujarat High Court.
You can mention yesterday's number because it'll be so much easier for us, because we have just.
501.15 months.
4 and 1. 14 and 15 are connected, right?
There are 3 petitions, I believe, my lords. Soumya and others, Kirti Agarwal, 14, 15 and 16 ballots.
Thank you.
The 1-4, you are appearing in 1-5.
Yes, my lords.
So chief doesn't.
My lords, at the outset, I must say that there is a difference between the matters that were argued yesterday and my matter, in so much so that the question of the reference of Tej Prakash is not directly involved. The common link, of course, is that there is illegality involved that we are
But then
challenging.
why should we'll send this back to the 2-judge bench.
Your challenge here is basically on the ground that Shetty Commission as well as All India judges says that cutoff should not be imposed at all.
Yes, my lords.
That's the point.
Yes, ma'am. And my lord, what has happened?
That's not the issue for Vikrat.
That is why it is my role, my lords, as an officer of the court, to
Some
mention
of them are saying that.
that
This
it,
won't be covered by the.
Gujarat matters, you are saying the same thing, right?
that is right, my lords.
Then the point was whether
There is a right.
whether the
impose a
right to
cutoff.
impose a cutoff at all in view of the judgment in view of the Shetty Commission report and the judgment in All India Judges
Yes,
Association.
ma'am. The only difference, my lords, is that subsequent to the Shetty Commission, where a specific direction was given to all the states to implement, the Gujarat High Court in the year 2005 had in fact amended their rules in terms of the All India Judges
In
Association.
your case, the rule itself in 2011 provides for a Viva Voce test of 40% and a cutoff.
That is right.
Which you challenge the
That is
validity
right.
of that. Whatever.
So this does not arise before the Constitution bench.
I appreciate that, my lords. There is a difference in the question, but we are still challenging it on grounds of illegality and there's a
That's
judgment.
regular.
May I just have 1 second, because I'm appearing for the High Court, my lords.
Yes.
My lord, these rules were challenged, carried it up before this honorable court, and SLP was dismissed. I must point that out.
That you will mention before.
That you can mention before the regular bench, actually.
Very well.
And Millard, then you'll kindly consider whether this should go with Salam Samarjit, which was referred by Lordship yesterday to the 3-judge bench, or these matters should go to 3.
Because there is no difference of opinion here. Samarjit was because of the
But
difference of
Miller, exactly the same issue again. Salam Samarjit was again on the same issue.
Oh, I see.
My lords,
We refer it to a 3-judge bench. But the thing is, the moment I say 3-judge bench,
Something else.
and what will happen is it will take a little more time. If you go before a 2-judge bench, you'll get a bench hearing immediately.
2022 appointment.
That is the reason
in
in many cases, facts would have led to the dispute being resolved. We don't really know. These are 2005 rules and 2019 is the advertisement. So therefore, let it go to the 2-judge regular bench.
That
And
bench
if they
can
want,
take
they
a
will
call.
refer to jury. Or else-
As a lordship.
Because despite holding in favor of the petitioners in the other case, just because of passage of time, you won't grant relief. So it's better that you should try and get a
That is what we're
opportunity.
trying to beseech, that even in these cases, there is
Therefore,
illegality.
strategically, 2 judges bench should be the option for you.
I
You
appreciate
are
that.
appearing in which matter?
6.
Okay, my lord.
This?
So whatever you
That can be.
argue.
The learned counsel appearing on behalf of the petitioners, Gujarat wale matters mein, the learned counsel appearing on behalf of the petitioners are agreed in stating before the court that the issue which has been raised in the reference to the Constitution bench in Tej Prakash Pathak, Pura Naam Le Lo, does not arise in this batch of cases. Full stop. Hence, it has been submitted that the matter may be placed before an appropriate bench for disposal. Full stop. Mr. Nikhil Goyal, appearing on behalf of the Gujarat High Court, also has no objection to this course of action. Full stop. Hence, these three petitions shall be dealing from the batch of cases before the Constitution Bench and shall be placed by the registry before an appropriate two-judge bench for taking a considered view of the matter.
My lord's only request is for it to be early listed,
The
madam.
registry shall do so within a period of 2 weeks.
Regret the opportunity of appearing before your lordships.
I was also thinking that you would appear in the argue. This is a very interesting point to argue.
My lords, I can navigate. Right, my lords.
Now, which is the next lot?
गुवाहाटी
कल केरला हो गया था ना? गुवाहाटी हो गया, मणिपुर हो गया, केरला हो गया।
गुजरात का problem ना
ना पर-
मनोज गुवाहाटी
You are appearing for
Sorry.
Guwahati. There are three matters from
Yes.
Guwahati.
Guwahati,
Guwahati is 501.2, 501.3 and 501.11. Yes.
advertisement.
मनोज in my case like Mr. Mukherjee had pointed out yesterday the rules which are there the Assam rules were implemented in Manipur
Yes.
so the same rules apply to my case now allow me to
So should this follow the same course as
No.
Manipur then?
no I'll tell you why Manoj in Manipur's case on the 12th of January 2015 the full court takes a resolution. Thereafter, that resolution is communicated to the petitioner therein, not the resolution, pardon me, the fact that he has been called for a viva voice. In my case, what happens? I'll start from after the viva voice, my lords. The notification for advertisement was issued on the 18th of January 2011, which is, my lords, it's annexed.
Take the dates from you in a minute, but
Yes.
just give us in
Yes.
in
In a
1
nutshell,
minute
I'll
just
tell
the
you.
essence of the matter.
Just the three dates you just give
Yes.
us. Advertisement,
My lords, advertisement
and
is
amendment.
18th January 2011,
You are in 501.2, right?
501.2, Vishwajit Prasad versus Guwahati High Court. 2, 3 and 4, my lords, connected, same line.
Yes. You are appearing in all three
Yes,
and 501.11 also.
yes, my lord.
That is Mufida Haq versus High Court.
Yes.
All right, tell us the dates. Give us the dates. So that we can-
Like I said, 18th January 2011 is when the advertisement was published in terms of the rules then prevalent, which is the Assam Judicial Service Rules 2003.
Rules 2003.
Yes, my lord.
Yes.
My lord, thereafter the preliminary examination, I'll not give that, that's not really important, my lord. I'll come straight away to the viva voice. My lord, the viva voice was conducted
29th October.
on 29th of October 2011. My lords, now this is where the difference starts. Now, the rules say, which Mr. Mukherjee had shown to you yesterday,
Complete the dates so that.
my lords, 29/10/2011 is the viva voice, and the select list, which is the final list declaring the successful candidates, was published on the 1st of December 2011. So this entire process took a period of 12 months, right from January until December.
Right. Right.
My lords, now the only difference in my case is that after the viva voice was concluded, by way of the rules, it was prescribed that they ought to have published the cumulative grade list, the merit list. Now, in my case, there was no merit list which was published at all. So when the results were declared on the 1st of December 2011, they only published the names of those 5 candidates out of the 19 candidates who were called for viva voice to be selected for the grade 1 services.
And 5 candidates notified.
Yes, my lord. Now, thereafter, I approached this honorable court by way of a 32, which was withdrawn with liberty to go back to the High Court. I then go back to the High Court by way of a fresh writ petition, my lords. Now, in that writ petition, prior to that writ petition, I also filed RTIs. Soon after the results were declared, which is 1/12/2011, I filed RTIs on the 7th and 9th of December 2011, seeking the information of the marks obtained by each of the 19 candidates who appeared for the Viva Voice after having qualified the mains examination.
So Viva was conducted for 19 candidates.
19 candidates.
Yes.
My lords, now after I sent my RTI, after the declaration of the result, we were hopeful that the RTI would disclose the marks, but the RTI came to be rejected after a period of 1 month, which is a statutory time.
Right.
Thereafter, my lords, like I said, on the 13th of February 2012, I approached this honorable court under Article 32, but that petition was withdrawn with liberty to go back to the High Court. Thereafter, I go back to the High Court in July 2012 by way of a fresh writ petition. Now, my lords, this is where the interesting part comes in, that until now, I don't know what my marks are, what I have obtained either in the mains or in the Viva.
Yes.
Now, before the High Court directs on the 8th of November 2012 that you please disclose the marks to the unsuccessful candidates who are petitioners before the High Court. So then by way of a letter which was issued to me by the High Court on 9th of November 2012, the marks were disclosed to me. My marks, the unsuccessful candidates and the 5 petitioners who basically approached the High Court.
Yes.
My lords, now after the marks, my marks are disclosed to me on the 9th of November, the High Court files its counter affidavit before the High Court on the 26th of November. My lords, if I may be allowed to read 2-3 lines from that counter affidavit.
Just tell us orally.
Tell us orally.
Yes, my lords, in that affidavit, the High Court says, citing the rules, and I'll take you to that rules, which my lords had rightly pointed out yesterday that it's not for interview, it's only for cumulative marking on each questions of written examination. But the High Court says that they had the power under the rules and they have exercised their discretion rightly. While
What?
in the counter affidavit, they say that by prescribing a benchmark of 40%, there has been no error in jurisdiction committed by the High Court.
No, what they say is 25th of November, they have passed a proceeding.
Yes,
We didn't get that. 25th of November is the decision which was taken
yes,
to prescribe a cutoff.
yes,
That is what has happened.
yes, ma'am.
25th November.
Was conducted on after the Viva was.
After the one.
After the Viva.
That's the crucial.
25th of November.
25th
2011.
The proceedings. You can. So that you are saying post-interview.
Post-interview, my lords, they have introduced a benchmark and they have said they have exercised their discretionary power while exercising that benchmark. Now, my lords, without getting into the judgments and everything, we are not challenging the power of the appointing or selection authority to fix
The bench.
any minimum marks that they can fix. That's a matter of policy decision. What we are challenging, which is why I say that we fall under the reference, is because those rules were made applicable after I played the game, after I participated in the interview.
That's
Yeah.
25th of November.
The reference clearly arises here.
Yes, my lord.
If I may clarify, there is a factual error. I'll point it out once.
Just tell us in a second. I mean, we
This,
can. This,
Cutoff mark was fixed for language paper, paper 4, not for Viva-Voce.
Correct.
so when was it fixed?
It was fixed later, but as far as
Give us the
25th
date.
November.
25th November, right? When was the cutoff for the language
it is
paper fixed?
prior to the Viva-Voce, because only
Show
those
us
who
the-
scored.
Just give us that.
Crucial point.
Yeah, that's the
What
most
you must
important.
Specific date it is coming, because the rule
So
doesn't.
just give us the date. He will agree with that. Show us, because on the record, there can't be two differences.
No, that's what I'm saying. The date specifically is not on record, but it is prior to Viva-Voce. Because
That's
unless.
what you will have to demonstrate to us that it
That,
is.
that,
correct.
yeah.
It's there in the page one, this reply before the High Court. It says 40% cutoff mark was fixed for language paper.
Is it correct that the cutoff was
Well,
fixed for the language
allow
paper
me-
only?
No, allow me to clarify, my lord.
All right, we'll hear you later, yes.
Allow me to clarify. My learned friend has rightly pointed out this thing, but allow me to clarify. There were 4 papers for written examination. Paper 1, paper 2, paper 3 and paper 4. Paper 4 was the language paper. Language paper was only a qualifying paper, which is in the Assamese language for the state of Assam, because since grade 1 officers will be operating in the district judiciary for the local language. Now, my lords, para 10 of their counter affidavit before the High Court, that paragraph has to be read as a whole, and preceding that para, they deal with the language paper. Para 10, they say that with regard to the statement made in paragraph 9A of the writ petition, I say that by prescribing a benchmark of 40% in the paper 4, the High Court has committed the High Court had not committed any error in law or jurisdiction. Now, this is the interesting part. The selection authority has always discretion to fix its own standard of evaluation, and the High Court has exercised such discretion. No discrimination or arbitrariness has been directly or indirectly done therein. A written examination is not sufficient to assess overall intellect and personal quality of the candidates, which can be done at an interview only. So, my lords, this benchmark of 40% could not have been fixed for the language paper, because if you read the counter affidavit before the Supreme Court,
So they seem to have done it for both.
they seem to have done it for both. And in any case, my lords, the language paper is a qualifying paper. That doesn't add to my marks while calculating the cumulative grade list.
So you have no problem that they fixed a benchmark of 40% for the language paper.
My lords, this statement is actually,
You have cleared the language paper?
yes, which is why I was,
Then that's irrelevant for you.
that's irrelevant.
But then, therefore, you are claiming that, well, apart from the 40% benchmark for the language paper, they also fixed a qualifying cutoff for the viva voce.
For the viva voce, which is evident at para 10 of the counter affidavit filed before the High Court, which I just read out to you, my lord.
But it can't really be a matter of averments in the pleading, in the affidavit. I'm sure there would be a proper decision taken as to whether it is intended for a benchmark for the written exam or viva or what.
Finally, we need to see.
No, you must check up and tell us. It can't be, don't say that I have the file with you. Tell us what the file says.
For paper 4 is language.
So there was no benchmark, there was no cutoff for the viva?
No, the cumulative mark was taken. They scored much less. That was their grievance. All of them scored less than 10 mark out of 50
In the interview.
in the interview. Total of both 3 papers plus the interview, viva was, together they were all below the selected 5 candidates.
Then they're out then if that is so.
To us that.
Show us the relevant file then. We'll just look at it, we'll look at the record, then the reference.
A matter of controversy, actually.
Because he says that as a High Court, that we never fixed a benchmark for the interview. Now, maybe they said that in the para, but it's a matter of record. It can't be a matter of the counter. Let's just see it. Because have you flagged it? Have you flagged the relevant part? Don't make us go through the whole file now. एक मिनट उन्हीं को दे दीजिए वो फ्लैग करने दो ये क्या है
This is a judgment. No, this is a full court. This is exactly 25th November. This is what we were to see.
all right let's just see quickly
Correct.
this.
This was not there on record. I was looking for this. Correct. This is exactly relevant portion.
The 4th page. 3rd page, at the back side.
Yes.
The marks are there, as in the district service. This is the committee report. This was approved by the full court.
Have they imposed cutoff? It doesn't say that they have imposed cutoff anywhere. But they are saying that they have the power to do it and all that.
In the first page, they say as well as
Just-
17.5% mark out of 15 paper 4 at the last line. Called for interview and bypass.
So Jose, the 5 persons named at page 7,
Yes, ma'am.
they are all in seriatim with the highest aggregate
Yes,
score.
they are all 5 in Syria.
That's what I noticed.
I have calculated it here, my lord. It's all of them are above the expectations.
Ones were selected and they. Jose, it appears that you have also added the marks of paper 4.
No, that's here it is added, but I have separately calculated, my lord, for the purpose of selecting 5 of them.
He says, for you, minimum prescription on the basis of which he was excluded. That doesn't seem to be there.
No, there is no decision. There is the rule provides for suitability. So those who have not,
But contrary to what you are saying that, we never took the marks of paper 4 into account.
right,
You have to only qualify. You have added the marks of paper 4 also.
no, that is for the, here, but the total calculation, it has not taken into.
No, but if you can go to page 4, for instance.
Right,
Abhijit Bhattacharya is the first candidate.
right.
Just a test case. Now, if you see,
First 3 papers, total 188, my lord.
now just see, Pranjal Das is the first one who gets 284.25, right?
About 11th or 12th item there, Pranjal Das.
Kanchal Das, right.
He is the first one in merit aggregate. Let's just calculate his marks.
Sorry, my lord, that one. On page 4 only.
Page 4, the chart.
Pranjal Das is the highest candidate,
Yes.
284.25. All right, take the first candidate, Abhijit
That's right,
Bhattacharya.
my lord. That's
Take the first candidate, Abhijit Bhattacharya,
right.
who gets 257. 257 is the total of 74 plus 67 plus 47 plus 29 plus 40.
That's right.
So you added the marks on paper 4 also.
No, that is for, that's for making a statement, my lord. But
All right, then
total of first 3 papers and the interview comes to 228.
228.
228.
Okay. So,
If I can just say who are all the selected candidate, the marks, my lord.
the first selected candidate was Pranjal Das, right?
That's right. That's right, my lord.
So who gets 81 plus 74 plus 56 plus 42 points?
That's 253.25, my lord.
Okay,
Total of 3 plus 1.
okay. Likewise, for all the other candidates, selected candidates, you only took the 3 papers
That-
plus the interview.
That's
So you didn't apply a cutoff in the interview at all.
the interview, there is a suitability clause.
But did you say that you must get a minimum mark
No,
in the interview?
No, it was not stated anywhere. At least on the record, it is not there. Because all the 5 persons who are selected are above those who are petitioners here.
Oh, I see.
On total of 3 plus
And
1.
none of them were rejected on the ground that they didn't get 40% in the interview.
No, that's not at all.
It is not borne out of the record.
In fact, the
Yeah.
page
Just
6,
see page 6.
page 6, the
Let's
top
read that.
paragraph.
Yeah.
They went by Schedule B instructions.
That's right, Schedule B.
Schedule B instruction, that paragraph
I
you read,
read
the
that
top
Schedule
paragraph.
B, my
Yeah,
lord.
it says in other words, the
Hmm.
selection has to be made on the basis of the aggregate marks secured by the candidates in the written examination and viva voce.
No exclusion.
There's no exclusion there.
So if there is no exclusion, what's?
Then the
problem?
reference doesn't arise here.
Kindly have para 20 of the judgment passed by the High Court. What they
But
say
you
there.
make your submission, no?
Now you show us, we've got the record now.
My lords, para 20 of the judgments clearly says that because the petitioner's hearing did not obtain 20% marks in the Viva voice, therefore they were found suitable for appointment.
Unsuitable. you mean.
Unsuitable, sorry, my lord,
Right.
stand corrected.
No, but that's not so. We've got the record now.
My lord, the point is that this,
Whatever
this,
the High Court said in the judgment,
my lord, this record which my learned friend has produced, this record was never made available to me, number one.
have a look at it for 2
No, no,
minutes.
no, these are proceeding, actually, the whole
These
thing.
are official records.
The whole thing turned on your argument that the proceedings that took place on 25th of November 2011
Yes.
were post-interview, and during that, by virtue of these proceedings, an imposition of cutoff was imposed. That's the only point to bring you within the ambit of the reference.
These petitions.
My lord, but
That
then,
is,
but then
so we have seen this.
no,
Dismiss the petition, no point in sending these back also,
There's
because there's
nothing
nothing
in
in
this
this.
my lords may kindly appreciate
And
one thing.
2011 advertisement, you have to make out a case, 2011 advertisement, and matter has been pending under the assumption that they have imposed this. We have seen this, there's nothing in this.
My
There
lord,
were
the High
two
Court,
further selections afterwards.
Yeah. We'll close this, I think, now.
We will-
All right, chalo. This is a selection to, again, the district official.
Grade one, grade one.
Grade 1
That's-
service. You call it grade 1 in Assam,
Direct.
right?
my lord, may
And
kindly.
the rules are the Assam Higher Judicial Service rules
2003,
of
2003.
2003.
All right. The selection in this batch of cases, the selection which is in question, the present batch of cases, is to the grade 1 service of the Assam Judicial Service, which is governed by the Assam Judicial
Judicial
Service
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 Rules
rules.
2003.
Full stop. Next. The relevant dates for the purpose of evaluating the merits of the petitions are as follows. Colon. 1. The advertisement on 18th January 2011, the advertisement was issued under the Assam Judicial under the rules of 2003. Full stop. This was followed by the written examination, which consisted of
Three
pa-
papers.
three papers, and for three
Language proficiency.
which consisted of four papers. Full stop. Of these, the fourth paper, into brackets, paper 4, was for language proficiency.
For the region.
For the region. Full stop. On 29 October 2011, on 29 October 2011, the Viva Voce was conducted for 19 candidates. Semicolon. 3. On 25 November 2011, the Committee for Recruitment of Judicial Officers conducted its meeting for selection of candidates for direct recruitment to grade 1 of the Assam Judicial Service, Tripura Judicial Service, and Mizoram Judicial Service for 2011. ये तीनों का था, ना? 4. On 1 December 2011, a select list of successful candidates was published, in which 5 candidates were notified to have been selected. After withdrawing a petition which was filed before this court under Article 32 of the Constitution, the petitioners moved the High Court in a petition under Article 226 of the Constitution. Full stop. During the course of the hearing of the petitions, the High Court directed the disclosure of marks, following which marks were disclosed
Only of the unsuccessful candidates.
to the unsuccessful candidates who are before the High Court. Full stop. Next. The submission which has been sought to be urged before this court is that you lost before the High Court, right?
I lost.
The petitions failed before the High Court. That's not anything. Full stop. The submission which has been urged in the proceedings before this court is that after the interview was conducted on 29 October 2011, a cutoff of 40% marks was prescribed by the Committee on Recruitment on 25 November 2011. Full stop. In order to support the submission, Learned Counsel relied upon the counter affidavit which was filed before the High Court. Full stop. In order to obviate any controversy on the factual aspect, the learned counsel appeared, Mr. Jose, appearing on behalf of the High Court, has placed on the record copies of the minutes of the proceedings of the Committee for Recruitment of Judicial Officers held on 25 November 2011. Full stop. The submission which has been urged on behalf of the High Court is that that paper 4, which was a qualifying examination for language proficiency, in which a cutoff of
17.5 mark, that is 35%.
of 35% was adopted. Full stop. The minutes which have been placed on the records make it abundantly clear that no cutoff was prescribed for the interview, and the merit list was drawn up on the basis of a cumulative aggregation of the marks which were obtained in the 3 papers of the written test and the interview marks.
My lords, if I may, I really apologize, my lords. If I may just say this, my lords, merit list was never published.
No, we are saying merit list was drawn up, we are saying. In view of the above factual background, the issue which was sought to be raised in the reference to the Constitution bench in Tej Prakash Pathak, so and so, would not arise in the facts of the present batch of cases. Full stop. The petitions are according to this.
My lords, if I may kindly say, just say one thing, not on
उसके
the
पहले
merit.
ये भी लिख लो, एक और लिख लो. The selection in the present case pertains to the year 2011. Full stop. The officers who were selected in pursuance of the selection process have already taken charge.
There
Full
were
stop.
other
The High
rules
Court
and-
has also has also apprised this court that subsequently 2 further selections have taken place in the state, for the state judicial services. Dismissed. That's all right. Chalo. So now we are done. वो मेरा ये भी दे दो, हाँ? So now we are done with Guwahati.
My lords, if I may just say,
Yes.
my lords, I agree that I am out of the reference, so I really don't have much to say. But my lords, the only thing which I can say before my lords is that my lords have themselves held in number of judgments, like in state of Jammu and Kashmir was a district bar association, which is judgment written by my lords. My lords have clearly written that an important requirement of public appointment is that of transparency, my lords. My lords, in my case,
You're undoubtedly right that they should have told
Lords,
candidates them.
I bow down to what my lords are saying.
No
I
doubt.
only say
The
this. My
question is
lord,
that you will not get any relief at this stage because, you know, the whole basis of the petition is now that we have verified
my
it.
lord, I only say that when this rule of law is, when my lords are adjudicating upon this,
Transparency
my
would
lord,
mean now, look, we can't, in a 2011 selection, we can't set aside a selection on the ground of a lack of transparency, provided we are satisfied that the merit list was drawn up properly, which is what is found from the records.
DPM.
Otherwise, go to the next.
We'll go to the now, we'll go to Patna now.
Patna. This is even worse.
Right.
Sending
Yeah,
them
so
back
as
again.
what your lordships indicated that your lordships thought, what I thought is I put my submissions in 5 pages, though these issues don't arise, but since your lordships thought if I could assist your lordships on these 2 issues, I thought I'll just put it down, and I'm sorry, it's just hard copy because I just.
Okay. No
This lordships have it.
But we will now first see the facts.
Whether it will arise or.
Does it
It doesn't
arise?
arise at all. I said
It
yesterday.
doesn't arise.
For moderation.
For the evaluation process.
It doesn't
The
arise at
evaluation
all. I said
process
yesterday,
That
but
has
since your
been
lordship-
the challenge in the writ petition.
You have not.
But
The
what I
issue
was-
is not arising in the present matter.
But in my respectful, but the Tej Prakash reference also doesn't arise. That's what I thought. I have tried to figure out if your lordships is.
Now just
I'm
tell us,
in the
here, just tell us in like 2 minutes.
Yes.
What are the facts here? So we'll see if there's any substance. If there's some prima facie point to be argued, we'll send the petitions back
Yeah,
to the
I'm very
2-judge
grateful
bench.
for that. I'm very grateful.
Otherwise, you know, there's no point in just prolonging the agony of these
Absolutely.
candidates further.
Yes, Avinash Kumar.
Avinash is 501.1.
Yesterday.
Milord, the advertisement in this case was published in 2015, in January 2015. Yes, ma'am. The advertisement was published in January 2015. ma'am. This was a district judge entry level, direct from bar examination 2015. On 22nd March 2015, a screening. Today it is 501.7. Yesterday it was 501.1.
Yes.
This is writ petition 165 of 2017. ma'am. Yes. ma'am. May please. ma'am.
Only those facts, Mr. Sharma, which will
Just give us,
first of all make us decide whether it falls within the reference or not. If it doesn't fall, we will protect you. We will not state
Yes,
unless it's so.
Unless it's so obviously
Obvious
that
that
we
that
don't have to
nothing
send
is-
it back before.
Just tell us those.
Just give us a few,
Yes.
3-4 dates, that's
Yes,
all.
this advertisement was published in Jan and
Correct.
then.
Jan of
March
2015, right?
Screening tests were taken. So where I qualified in the screening test,
When was
Then
the
the-
screening test, Mr. Sharma?
22nd March.
22nd March 2015. Written examination was conducted on 12th July 2015. But I obtained 127 in the written examination. However, the qualifying marks were 125.
You got how many marks?
127.
Qualifying were 125.
Yes, minutes. So,
So you qualified?
but I was not called for interview.
Yes.
The total 81 candidates were called for interview. madam. Later on, that list was also shuffled and then 5 candidates were dropped from there, 2 added later on. So this was some juggling up. So ultimately, I filed a RTI application on 18/4/2016 to Patna High Court, seeking a copy of my answer sheet for paper 2. Paper 2, I had obtained 53 marks. So in paper 2, my lord, when I was given the answer sheet in the first week of July 2016, so I had received 0 marks in answer to question number 8, 10, and 23. So there were several limbs of the question which were answered by me. So all the limbs of the answer were given 0 marks. In a corresponding to this, question number 3, another candidate was given on the same answer 5 marks. So I was
Given
just
0 for questions 8, 10, and 23.
8, 10, and 23.
Right.
So there were several limbs, 3, 4 limbs in the question.
What's the grievance now?
But I sought re-evaluation.
That's it.
The High Court said there is no rule to provide you re-evaluation.
So that's the issue.
That's the issue.
That's the issue. Re-evaluation is the question.
Yes, ma'am.
Why this is stuck?
So it's not a case of cut-off
Where is the
marks.
right to
Moreover-
revaluation?
Yes.
And moreover,
Sanjay
moreover,
Singh's
your
judgment
rules
would apply in my
provided a
case.
cutoff. We-
Rules provided a cut.
What was the tag? Why was it tagged here? This Tej Prakash doesn't arrive here.
I was not
several
very
applications
for
also
Patna
to
at that
DTAG.
point of
But now
I
tell us
made a couple of
something,
applications also to DTAG, but somehow it did not.
Well, there's an application to DTAG also.
So it was unfortunate on
Now,
my part.
Why should we do this? Let's get a statement of facts from the High Court, what actually
Yes,
happened.
No,
please,
I'll do.
yeah,
He's really concerned with questions 8, 10, and 23 of paper 2.
Correct.
You know, the easiest thing for us as a constitution bench is that, look, we'll send it to 2 judges, but let's find out whether there's something worth arguing, then we'll do that, then. Now tell us this, you'll tell us in 2 minutes what the facts are.
Also, the counter affidavit, which is I have inherited the brief, actually does not address, apart from saying there is no procedure for re-evaluation. So therefore, we can't entertain a request for re-evaluation because as per law laid down by your lordships in Maharashtra State Board, there is no provision for re-evaluation. So now he has filed a writ petition where your lordships will then have to see whether what his allegations are that his question paper 8, 10 and 23 are marked 0, despite the fact that his answers were correct or even have some substance. So, I mean, he can show me the question paper. If I find that, yes, there is substance, then of course, I'll inform your lordships, yes, there is a prima facie case.
2015, Mr.
16,
Sharma.
15, 16.
Mr.
exactly.
Lord, I am
Sharma,
already
otherwise-
judicial officer.
Mr.
I
Sharma.
was selected in the subsequent examination.
Sharma,
I
just
am
see what
working
my
as a
brother is
judicial
saying.
officer now.
He's already working on
On,
that.
on aggregate score, you come below.
Only 2 marks, by 3
Correct.
marks only.
On aggregate score, you come below, meaning thereby your merit would not sort of.
Only by 3.25 marks, my lord.
Subsequently, I think 70.
Only by
You're
3.25
already,
marks.
you're
If I
already in
get
service.
two-
Yes.
I'm so sorry, 2.25 marks. If I get one mark each in all these questions.
This 1 mark in a given situation could be a very big
One is a
difference.
world of a difference.
No,
It's not just,
but
you
one
can't
needs
just sort
to
of-
see
Mr. Sharma,
what are my answers.
Which year did you pass after the next?
2017.
17.
No,
You made it now.
17
Not
now.
the seniority would be affected. my lord. I would get
Yeah,
benefit
no,
of the seniority.
Even if
That-
we allow, you know, this.
Seniority, now we are not
Those who
going
have
to give
been working.
So we'll say that, though the petitioners, both matters, right?
One. Second one is different.
All right.
Second
Though,
one is
501.1 mein kar lo.
Yesterday's 5.
Though the petitioner did not qualify for the, in the selection process for district judges through direct recruitment in 2015-16, it is common ground that he has since qualified in joint service in the subsequent batch of 2017.
Recruitment of 17. May have got appointed in 18 if I'm not mistaken.
Stop. In view of the fact that the petitioner has joined service after being recruited in a subsequent batch, no case for the exercise of the
Lord,
jurisdiction in
when these
Article
questions
32.
are required to be considered, not it would be
At
most
least in other
appropriate.
cases.
Because the High Court cannot brush aside my answers just like that. Lord. These answers are
Now
reasonable.
the
One
question-
has to see.
You know, but
Somebody is
assuming you're right,
accountable
we
here.
can't, assuming you're right, we can't give you seniority of 2000 of the earlier batch then.
No, it can be granted. my lord. If I am eligible, it can very well be because there were deficiency of seats also.
You should
All
have,
seats were not fulfilled. The advertisement was for 99 seats.
but you
There were only, I think,
Gone to the
65
High
or
Court first.
6 seats were filled.
demonstrated that, look, your answers are absolutely correct. You don't go to the High Court, you come in that 32 petition. You have to demonstrate ex facie that, look, my answers are correct and I'm
I
right.
will demonstrate, my lord. If my lord permit, I will demonstrate before my lords or before the
But,
appropriate.
you know, at the end of it, look, will we now say then 2023 that you should be given seniority of 2016 when you have already joined service?
Not if I am eligible, then it can be said.
And there's no provision for evaluation
The
in the
habit of the.
Exactly. Even in Kerala, where we have held that the High Court decision is wrong, we have not given relief.
I understand.
kind of
I'm
relief
live to
must
that
be
situation.
Can't
but in those
unsettle, now the
I was
seniority of
working.
people who have joined 6 years ago. Other people have joined service 6 years ago. We can't now suddenly unsettle seniority in service.
This,
It makes
the
very
answer
serious
to this
problem.
would lie in the very fact whether there were leftover vacancies of that year or not. And whether they were filled subsequently or not. So if there were leftover vacancies and they were not filled in subsequently, then my lien can come into play. If I prove my case,
There was
then
no
in that case,
provision
I
for
can be.
evaluation.
No, Mr.
The rules are
Sharma,
until time.
we'll consider.
The principles of justice, my lord, this is against
No, Mr.
totally
Sharma, we
entirely.
can't now. We
against
must also
principles
look
of
at the
natural justice
concerns of
and
the
that's also
service.
by a high court, my lord.
Question
What's
501.
It calls for interference, my lord, with deep,
What's the other?
great.
501.12,
Respects, madam.
the High Court had amended the rules and provided minimum marks in the interview. So, and that rules are in substantive challenge as being contrary to SETI Commission. There is no rules. Rules of the game have not changed during the selection process. So, advertisement and the rules provided for minimum marks, and they have challenged the validity of the rules being contrary to SETI Commission. So, I'm not sure why it is here,
Like that,
but this is a substance challenge.
Let me kindly post it before a two-judge bench. It would be most appropriate, my lord. I will plead my argument before it.
The issue which has been raised in the reference to the Constitution bench in Tej Prakash Pathak, Pura Naam Likho, does not arise in the present case. Full stop. The petition is detached from the
Grateful.
batch of matters and shall be placed before an appropriate two-judge bench by the registry at an early date,
Let me fix some time, you know, the 2 weeks as early.
within 2 weeks.
Deeply grateful.
No, this is 501.12.
1, 2.
Milord, in my case,
Your matter is 501.12.
Milord, I
You
respectfully
just
submit only one.
dictated the order very softly. Dismissed.
No, Milord, I am so sorry that I missed to hear it, Milord.
No.
Milord,
Anyway, now
the
we'll take
only
up
position that
Rajasthan.
has to be-
Now we'll take up
Milord, just
Rajasthan.
one last submission, Milord. The only situation that has to be seen by this honorable court at this stage, Milord. What were the leftover seats at that time which were not, completed? And then whether they were fulfilled in the subsequent years or not. There are vacant seats for that year. So it is not as if that I will
Not give you
overrun
notional
someone
We'll not give you
in my
notional seniority.
selection of that year today.
No, Mr. Sharma, we can't give notional seniority like this. Yes. Rajasthan now. Rajasthan, who's
But
appearing
one
in
thing
Tej
can be
Prakash
added, Milord.
Pathak? Tej Prakash
Milord.
Pathak.
Just one thing can be added, Milord, replicate the very stance taken by the High Court in this matter.
All right.
This
Tej Prakash.
requires Milord, consideration.
All right. Tej Prakash Pathak now. Miss Dr. Bhardwaj, what are the facts here?
Lordship.
This is
What is the item number?
The reference order that
This
clearly
is-
captures the facts also. So if you
Reference
not-
order.
this is 2009-10.
9, 10, 9 selection is of 9.
Lordship.
And for translators, who
Lordship, I will just explain if my friendly allows.
501.501.
501.
501
1.1.
and 501.2, Lordship, I am appearing for.
501. 501. 1 point?
Tarun Kumar and Tej Prakash.
All three, the first three.
501.9, yes.
Lordship, I have no idea about the third one, but yes, I am appearing in two matters, Lordship.
501 and 501.9.
9 and 10.
She is appearing in 501.9.
1 and 9, I am appearing, Lordship.
Mukesh Chandra Jain is same.
Same.
Same
Same
is
selection,
there, Lord.
all same.
And what about, all right.
Only 3 matters are there, Lordship.
Right. Now tell us what the facts are.
Lordship, the notification, it had come in 17/9/2009.
17?
9/2009. An exam date was 19/12/2009.
What was the notification for? For holding the exam for?
Lordship.
For translators.
It was for employees who were actually working as a judicial clerks, UDC, in Rajasthan High Court. They were already in services, Lordship. And this notification for those employees who are already in the job and just to shift, promoting to the
This
translator.
was for in-service employees.
Service employee. Lordship, 21 eligible of employees were appeared in the test held on 19/12/2009. There were 13 vacant posts of translators which was issued on 17/9/2009. Applicants applied as per eligible qualification which was possessed by them, which was only MA in English, Lordship.
There was Mubarak. 24/7.
Can I read
Go
notification
ahead.
of
Just tell us,
2009?
give us the date, give us the dates.
Lordship,
After the
dates is
advertisement, what
fine,
happened?
still I want to go.
That's the most important thing. Just tell us the dates and we'll go to the law.
2009, that I have already.
24.
17/9/2009, which was a notification, which was actually the Rajasthan High Court Staff Service. Applicants were invited for giving performer for the recruitment of 13 vacant.
Right,
posts
you
of
told us. And 21 appeared on 19/12/2009.
Lordship.
Then
And Lordship, then the result was declared
on
on 22/2010.
22/2010.
Lordship. Lordship, till now, we were not aware that the rules were changed one day before 19/2/2010, which we came to know actually when once we filed writ petition before the High Court, and there when the counter affidavit was filed by the respondent.
19th
It was
February. 19th, your results were declared on
19th
20th.
February 2010, the
19th,
notification.
they have imposed the 75%.
75%, Lordship, which was not even there, the
Right,
minimum
right,
and maximum, nothing was explained. It was for translators, which was actually to Hindi to English and English to Hindi. That was the only test prescribed in the 2009 notification. Kept vacant, only 3 were taken. Lordship, the employees who were, actually, they had appeared in these examinations, which were my petitioner, we all are petitioners. They had scored 71%, 69%, 68%, 68%, 66%, Lordship.
How much? 71%?
71%, 69%, 68%, 68%, 66%, 57%.
Below 75.
Lordship. And Lordship, these were the marks which were actually they got, which they were not even informed, even till when I filed my writ petition, I was not aware. When I
So
filed
your
my
contention is
RTI.
now those who have been selected,
Lordship.
those and was there a viva? Was there a viva here?
Lordship.
There was a viva here or no?
No, Lordship. It was only written examination.
Only written exam.
Because it was for
But
the
you were
translators.
75% minimum.
Lordship.
But
that
those who were
was
selected,
one-
those who were selected all got, 3 people who were selected got more than 75%.
They got Lordship.
And 10 persons
Lordship.
who were not selected at all
Lordship.
were all below 75%.
75%.
Were they,
but
were they bound to fill up all the
25%
posts? Were they bound to fill up all the posts?
Lordship, what I am saying, had I been knowing that I have to prepare in such a manner that it is a competitive examination, I would have
You are
prepared.
starting from the stage of preparation.
Lordship, this is not, this is against the Article 14, Lordship. I am not
It is
given a
not
chance.
into that apply.
Don't even
They were
know.
not bound to fill up all the posts.
No,
So forget the fact that they laid down the 75% criteria later. They were not bound to fill up all the posts. They said, we'll take the first 3.
Lordship, may I read the reference?
Not a case of
order?
a change of the rules of the game in that sense. You see.
Lordship. And Lordship, I want to
You
read.
see, in the earlier case, for instance, the Kerala case, what happened was,
Lordship.
yesterday, which we heard, because of the fact that there was a change in the rules of the game, then though these people who were excluded, they had higher marks in the aggregate, they were still not selected because they didn't get the minimum marks in the interview.
Lordship in.
That is the problem.
Lordship.
Here, all of you are anyway below 75%. The merit
list,
They just stopped
Yes.
at one particular
Only
post.
one line. There's, in the other cases, there was a revision in the merit list because of the change. There's no revision of merit list. It is still the same. Top 3, top 5, 75%, above 5. That is how it has been done in this case. So
Lordship.
there's no change in the merit list in terms of preparation.
No, there was
So that is all.
No.
In all other cases, there would be a change in the merit list because of that introduction of qualifying marks. That is the
Lordship,
distinction.
I want to submit, Lordship.
It was very straightforward.
Lordship, 2002 rules I have filed, Lordship, and I have given the copy also. Lordship, earlier it was 75% only, and why? Lordship, it is,
It pertains to
Lordship,
selection
Lordship, it is very important. I have
conducted
waited
by
so long.
the
Just one
Rajasthan
minute.
High Court
I am heard.
in
We
2009,
have seen that.
2009-10 for appointment of translators.
Lordship, may I read one reference order? Lordship, this much chance
Yes.
I should get,
Dr.
Lordship.
Bhardwaj, you've read the reference order, but the point of the matter is this.
Lordship.
Your case is that after the examination was held,
Lordship,
they decided to have a cutoff of 75%,
Lordship.
and therefore there's a change in the rules
Lordship.
of the game. And
Which was
therefore,
earlier again 75% in 2002, and again they had come and changed in
Right.
2009.
There was no
Lordship. There
cutoff.
No cutoff.
There was no cutoff
Lordship.
when the advertisement was issued. Now, what they did was they applied a cutoff of 75.
Lordship.
All right, they took the first 3 candidates and then didn't fill up all the 13 posts. They just filled up 3 posts and didn't fill up the remaining 10 posts. There are two. There's a basic answer to that. That they're not bound to appoint everybody at all.
Yes.
Second, you see, what we try to tell you as a difference, or possibly you didn't realize that because you were not here in that matter yesterday. In the Kerala matter which we dealt with yesterday, they decided, the rules provided that the selection will be made on the aggregate marks in the written examination and the interview. These petitioners who are before us yesterday said that you applied a cutoff for the interview.
Yes.
So though we had higher marks
Yes.
than the selected candidates in the aggregate of the written plus the interview, we have been excluded only on the basis of the fact that we did not score the minimum marks in the interview, which requirement came in later. So there was a revision of the merit list. Here, all that has happened is that they said, look, we will not take anybody who has less than 75% marks.
Now, Lordship, what
I could have
happened?
said
In
top
next
3
year,
also. I could have said top 3
next-
also. Instead
No.
of saying 75, I could have said
Then
top
what happened? Next year again they took the exam. They kept 75%. Nobody cleared the exam. 0. Nobody was taken.
That is what the
Then
translator is an important post for us.
to
We have the right judgment that have to be
that no
translated.
one-
There are so
nobody
many things that have to be
facts-
translated.
will take
Dr.
everyone.
Bhardwaj, this touches the first point that you made,
Lordship,
that you will have to prepare harder.
Lordship,
This is the first point that you made.
Lordship.
That's why.
Lordship, it is just the thing that now why did they come now? Again, the minimum maximum, there is nothing. You can come again because they did not get on 75%. That was the only year. That's the only year when, that means only my batch, I am suffering, nobody else. My next batch is lesser than me and still they are on the post, Lordship. Test of arbitrariness, Lordship.
Full stop. The selection was for in-service candidates. Full stop. The notification for the examination
Lordship,
was
I
issued on
apologize.
17 September 2009 for a total of 13 posts. Full stop. 21 candidates appeared at the examination on 19 December 2009. Full stop. The result was declared on 20 December 2010. Full stop. The grievance of Dr. Ritu Bhardwaj, learned counsel appearing on behalf of the petitioners, is that initially on 24 July 2004, the cutoff, which had earlier been prescribed in the written examination, had been removed. As a consequence of which, on the date of the advertisement, there was no prevailing cutoff for the written test. Full stop. Learned counsel submitted that on 19 February 2010, 1 day prior to the declaration of the result, the High Court decided to impose a cutoff of 75% marks in the written test. Full stop. This, it has been submitted, is arbitrary since it would amount to a change in the rules of the game midstream. Full stop. On the other hand, the submission of the High Court is that, as a matter of fact, is that the High Court decided to take only 3 candidates who had more than 75% marks, having regard to the fact that translators were being appointed into translators were being appointed. Full stop. Next. It is a settled principle of law that it is that the authority which notifies a selection process is not liable, is not bound to fill up all posts. Full stop. However, it is equally well settled that such a decision must stand the test of fair procedure, of fairness. Not a case where candidates who are otherwise eligible for being considered were excluded as a result of the application of a new rule midstream during the course of the selection process. Full stop. The High Court was not bound to fill up all the posts which were notified for selection and decided to fill up only 3 posts, having regard to the necessity of appointing persons of the requisite merit as translators. Full stop. In the circumstances, the High Court eventually decided to fill up only 3 posts, leaving 10 unfilled in the selection of 2009-10. Full stop. The were again appointed only on the basis of merit, and the petitioners ranked below them in the order of merit. Full stop. Vote rejected. Yeah. Rejection of the petitions under Article 226 of the Constitution by the High Court has led to the institution, has led to the invocation of the jurisdiction under Article 136 of the Constitution. Full stop. For the reasons which have been indicated above, we find no merit in the petitions. The petitions shall accordingly stand dismissed. The reference to the Constitution bench shall accordingly stand
Lordship,
answered.
may I submit now, Lordship, one more thing, Lordship. We were not at all here for the merit of the candidates, Lordship. We had to decide one main important question.
As a follow, the reference to the Constitution bench does not arise in the facts and circumstances noted above.
Lordship, may I submit now, Lordship? I maybe heard only one point, Lordship.
Yes.
Here we were discussing about the whatever rules are made at the last time when the selection process has already started. This point had to be decided by the Constitution bench, Lordship.
All right, ma'am, I'll tell you one more reason.
Lordship,
Suppose they had not altered
Lordship.
that, suppose on the 19th of February, they imposed the bar of 75%.
Lordship,
Suppose they had not done that.
Lordship.
Were they still bound to appoint you? No.
Lordship, I am not at all talking about my appointment. I am talking is, Lordship, what now Lordship says today. It will be followed in all
Suppose-
exams.
no.
We will not be
No,
told
no,
any
no.
syllabus and suddenly
No,
there
no,
will be
no.
any change at any.
Suppose, ma'am, suppose we ignore the decision which the High Court took on the 19th of February to have a minimum requirement of 75% in the written exam.
Lordship,
And suppose there was no minimum requirement of 75%.
Lordship.
All of you had therefore qualified. Even so, the High Court could have said, we are taking just the first 3 candidates who have above 75%. That's the difficulty in your case.
Lordship,
They can always say that we don't want people who have, say, got 57 marks out of 100 in the
47, it
exam.
should go to
taken
47 if 13 were
any
to
of the
select.
rule can be set up by the Honorable High Court or Supreme Court, Lordship, but we should be informed in time. I am just asking about that point, Lordship, what we had to discuss today in this Constitution bench, not the merits, Lordship. We are not talking about whether I should be taken on this post or not. I am talking whether such rules
We should be very careful
made
about
mention.
answering questions in the abstract.
Yes.
We should be very careful about answering
Lordship,
questions in the
may I,
abstract.
that's why, Lordship, I requested to read referral judgment, Lordship,
Read
the
that.
9, 10th, 11th, 12th, Lordship, if you will see, there, he himself, Lordship, he clarifies that this is wrong when arbitrarily.
That will
you
arise
just
in a
say-
case where there is a right of appointment, but
Lordship.
there is a violation of that right arbitrarily. In your case, the right of appointment doesn't arise
Right
because
of appointment to Lordship, making of the rules when the selection of process is started, Lordship, it is the
arise.
point, not the.
Now we are left
appointment.
with 501.8, which is National Council
Lordship,
for
that
Education
12 of
Research and
Manjushri
Training.
is very clear about it, Lordship.
All right. Ma'am, sometimes you have a law of this court which is holding the field from 74. Then you have a judgment of 2008. Let benches consider those cases and the facts of each case. Sometimes it's better not to, lay down these very rigid rules in a constitution bench.
In
you know.
fact,
Both
both
are-
are different
Lordship, but
aspects. in
bigger
fact.
issue
Particularly
was
in service
before
matters,
the
always
election, Lordship.
wise to look at the facts of a case and then take a decision, because you can adjust the equities.
so upon 501.9 and 10, are they different?
No,
No,
no, same
Lordship,
selection, process, same selection.
We order same.
501,
without-
501.9 and 10 में ये order आ जाएगा.
Yeah.
अच्छा, now 501.8.
Lordship, this is regarding conducting of examination, that is National Talent Search Examination conducted by the NCRT, Lordship. All India examination, selecting candidates on the basis of their merit to grant scholarship.
Can we have your name, please, counsel?
Lordship.
Your name?
Ashok Kumar Panigrahi, Lordship.
Yes.
ये matter होने के बाद and before we take up the Yes.
Yes.
Lordship, initially when the examination was, for the examination, the advertisement and the further process was on.
This is for a scholarship, is it?
For scholarship. It was initially that there are two parts of the test, that is mental ability test, then there is a scholastic aptitude test. In the scholarship aptitude set, there are two categories. One is language test, the other one is subjective test, that is science, mathematics, and social sciences, irrespective of the, as per the choice of the candidate, whether they are choosing science or social science or mathematics. Lordship, initially it was the issue that the language score will also be considered for the purpose of calculating the total merit of the candidates to judge their performance in the examination.
Language score also.
Language score, that is English. During the process, when the examination is on, there are several complaints received from various corners of the country that the English language, because most of the candidates are from rural background, they are not much conversant with the English, so English should not be made as a deciding factor to deciding the final merit of the candidate, rather it should be made qualifying. So this matter was referred to a committee. Committee duly considered the issue and decided that let the English be considered as a qualified, not as a merit deciding factor.
Yes.
But the issue is that this was done when the examination was on. That means the candidates are already applied and they already appeared in the one part of the examination. The other part was to be followed. So during the process, this decision was taken to make the English qualifying. But there are certain candidates, those who have scored very well in English, they made a complaint. So after declaration of the result,
he's saying
that look, if our English mark would have been considered, we would have.
Now, where does your candidate client fall?
I'm for the institution, Lordship. I'm not for the candidates. Because the Rajasthan High Court has allowed this petition relying on the judgment of K. Manjushree and this Samarjit, which is on the
Now tell us one thing. Oh, I see. Now, therefore, the committee said that English should be treated as a qualifying mark and not for merit.
Lordship.
Some candidates who had scored high in English said that you can't.
No, they went to read. To read High Court Rajasthan. The Rajasthan High Court has ruled in their favor, stating that look, you cannot make this rule during this process because the rule of the examination cannot be changed, relying on the judgment which is under reference, Lordship.
Now, what happened? Were the scholarships given to those then?
No, the problem is, Lordship.
What happened then?
My result was, the read came after my declaration of result.
Then?
I decided the result making English as a qualifying. There are two candidates. The order went in their favor. Let the English be considered to calculate the final result.
How many candidates?
Two petitioners here.
In the High Court, two petitioners.
Before the Rajasthan High Court, Lordship.
So eventually, did they get the scholarship or no?
No, so far because this order is under stay, Lordship. Because my problem as on date
How much is the scholarship?
It is some 1,000, Lordship, per month.
For how many months?
It is, if the candidates are performing well, it will continue till their post-graduation study, completion of their post-graduation.
And who is appearing for them?
Candidates, they have not given appearance, any appearance from
Nobody is appearing.
No, no candidates.
They would have finished.
They would have finished and lost interest. They must be now.
They lost interest. In fact,
they must be now somewhere in service. Now, should we decide it on this?
Lordship, my problem is that I have to review the entire result.
2017. This
was entire result
2013.
There are n number of candidates who has.
This is National Talent Search Examination 2013 or when it was?
Yes, 2013, Lordship.
Advertisement of 2013.
There are n number of beneficiaries who has enjoyed the benefits. And if I recalculate it again on the principle that considering the English language, the entire result may be completely changed. So this is the case, Lordship.
The scholarship,
They would have
etc.
finished
Oh, yes, everything,
Fine.
this order came even after declaration of my result, Lordship.
And you gave the scholarship to those students. There were fixed scholarships, fixed number of scholarships?
There are a fixed number of scholarships. I think 1,000 some odd candidate, based on merit, it will be given to entire country.
So those candidates have already. And now
Already,
this
already,
stage
Lord.
Now is in question. No
That
question.
is why these two candidates lost their interest and they didn't appear, given their appearance before this.
Other thing. So, and that's- This matter here, I think. We'll
Lord,
set aside the judgment of the High Court, I think, you know?
There's nothing.
We'll say survives. Yes, yes, Haripriya.
The problem is today, the Tej Prakash reference says that Manjushri has not taken into account Subhash Marwaha. So while your lordship has not addressed that issue in
It
this
has not
judgment.
arisen in any case.
Yes,
So
then your
therefore, in the
lordship will just
previous
clarify
order.
that Manjushri will hold the field because it's 3 judges and Marwaha has 2 judges. Because when it eventually goes back, we will come back to this dispute whether Manjushri is.
But that anyway held the field, right? Because it's a larger bench.
Holding the field, but the view taken by the reference order in Tej Prakash is that Manjushri was passed without reference to Marwaha. And therefore Manjushri has to be reconsidered. So today the problem will arise when matters go before individual benches, whether Manjushri should be followed at all. But it's 3 judges. Marwaha has 2 judges.
And just one more sentence, my lord, like in this example.
But they can release, the earlier judgment is 3 judges, no?
No, 2 judges. Marwaha has 2. Manjushri is 3. Your lordship is right, these issues may not arise in these petitions, but that doubt is now cast.
Because bro, in Manjushri para 12, in my learned friends, Mr. Bharadwaj's contention, Manjushri says, suppose there is no minimum cutoff, there are 13 people, you are bound to take the 13 best people. So you can't fix the cutoff. So that is what para 12 of Manjushri says. So if Manjushri has been applied in her case, she had a right to get the 13 people, first 13 had a right to get appointed. Now, because they introduced the 75%, people below 75% went off, which is why Tej Prakash
But
says.
you know, then what would happen is that if you are bound to take the 13,
Yes, my lord.
even if the 13th has got 40% marks, you're bound to appoint him as a translator.
But that is
That's
subject to.
that's a practical difficulty. Absolutely, I understand. But the future situations may arise where people who have got 74, 73, 72, they won't take the 13 because they say we have fixed a cutoff of 75%, which came after the results. So if you strictly apply para 12, factually lordship is right because there was no minimum. So somebody gets 1 mark, 2 marks, 3 marks, they may have to be taken. I understand that. But law.
And if I
The
may.
point is, where do we arise somewhere in a given case? It doesn't arise in these cases
May I
really.
speak
You know.
one more submission, Your Lordship? No, in Tej Prakash.
No, what could be done is when the matter we have now referred to two regular benches.
Yes.
So this could be thrashed out before the same 2-judge bench and let them apply their mind on the facts and overall perspective. Then the matter will come for reference to.
My only May I just make one submission? The Tej Prakash was passed by 3 judges, the reference order. Now, 3 judges have said that Manjushri has not taken into account Marwaha, which is 2 judges. And one more small submission. And it will be in Tej Prakash. And the reason, Your Lordship, is this, may I just make one more submission? Tej Prakash proceeds on the basis.
That doesn't arise,
It doesn't arise.
It is saying that.
Because then we will have to say that they are duty bound to take all the 13, irrespective of the marks. which you say.
Precisely. I agree with the Lordship.
Which is that you have to issue a mandamus that you must select everybody.
Mandate that.
Law doesn't mandate it.
Para 12 of Tej Prakash has misread Manjushri in my opinion, and they said if Manjushri was to be strictly applied, all candidates have to be taken, whereas Marwaha is contrary. In my opinion, para 12 itself is not correct. Manjushri does not say that specifically at all. So para 12 and 13 of the Tej Prakash reference order, if Your Lordship will read, that now is also by 3 judges. Now, today the situation will be, will everybody follow Tej Prakash's reference order which says Manjushri is not correct, or Manjushri which Tej Prakash is wrongly interpreted?
But the subsequent judgment is of 3 judges, right?
It's not a judgment, it's a reference order.
No. Manjushri.
Manjushri is 3.
3 judges.
Now, you can't doubt as a matter of first principle, you cannot doubt a 3-judge bench judgment on the ground that it has not referred to a 2-judge bench.
3 judges have doubted it. in Tej Prakash.
Right, but I think that doubt itself is wrong.
Then your lordship may have to clarify.
Unless we say that, the three-judge bench which decided the subsequent case is independently not correct law, then you can certainly look at it.
They'll have to see whether they will have to see whether Tej Prakash has rightly understood Manjushri, your lordships. They will have to see if Tej Prakash has rightly understood Manjushri.
Lords, I have, my lords, in fact, my lords,
Because Manjushri does not say everybody has to be on that list. Specifically,
Yes.
there is no such.
All right,
issue.
we can
do
do this. We can see the referring order in Tej Prakash.
We will clarify.
All right, in 5, and we'll just clarify it in 2 paragraphs so that, we are then done with it.
may make
Because
one
otherwise
submission,
that
my
will be
lords.
left out.
In fact, Manjushri was cited subsequently in many cases before this honorable court. And especially, my lord Justice, Honorable Justice Tigesh Roy was also part of particular case from Goa, my lords, was it facts of the Manjushri case, and this is totally different. Manjushri is not applicable. That was also a change of rules after the game is played. In many cases, though Manjushri was cited and tried to link it or tag it along with the constitutional bench, this honorable court rejected that and said that it has to be decided in its facts. And whereas
That's right.
That's right.
Tej Prakash as well as Marwa, there is no case of cut-off marks in the interview.
Yes, so those
There was no
line of Manjushri and line of Marwa is different.
I'll
It
just.
has nothing to do with Tej Prakash, it's totally different.
There's
No conflict is a.
Okay, we will.
All right, let's do this. Let us do this. If it comes to it, let us see the referral order and the 2 judgments. That's all. It'll take us 10 minutes to see that. All right.
Lordship, in my case, the only problem is that post 2013, I am conducting the examination, making English, making.
This matter we'll close because your matter now this has become infructuous really.
No, Lordship, the reason is
We're
that,
in your favor.
no, that is all right. But with respect to conducting the examination, because a single judge has allowed this petition relying on K. Manjushri. That was affirmed by the division bench. I am before your lordship. Candidates has not marked their appearance there. I think they lose their interest.
But there is no law which has been laid down in this matter, in the facts and circumstances of the case, because the candidate respondents are also, it's for grant of scholarships.
Yes,
For
Lord.
1 year period.
No.
Ah.
It is starting from +2 to postgraduate. Based on the
That would have
continuous performance, if they are
2017.
performing well, they will entitled to have the scholarship till post-graduation. But only my problem is that post 2013, after this examination, I continue with this standard that English would be qualifying only. At this stage, now tinkering with that principle of making English as an aggregate, as the High Court has ruled in their favor, will also upset the entire process, Lordship.
Do is in a minute, we will close this case and we'll just come back to Dr. Bharadwaj's case and you can just assist us for 10 minutes on Dr. Bharadwaj's case. We'll see if any conclusion may ultimately be the same, but if we have to just clarify the law in 2 paragraphs, we'll do that.
I'm ready.
Just say this. In 2013,
Lordship, my point is that they didn't qualify in the result. They only relying on the judgment of the High Court based on which they are qualified. Otherwise, result is not in their favor.
Oh, they lost. Then in past, you mean to say?
This High Court has said, consider his English language and grant them, they are qualified.
But,
That is the-
no, but if the English language marks were considered, they would have qualified, right?
Yes, that is the case.
That is,
the one.
that's the,
Then it's a.
in 2013,
That means in the entire result would be reviewed again.
NCERT issued an advertisement seeking applications from candidates for the National Talent Search Examination. Stop. During the course of the examination, candidates were subjected to 2 objective type tests, namely bracket 1, mental ability test, semicolon, and bracket 2, scholastic aptitude test. Let's stop. The first and second respondents were students at the class 10 stage applied for the NTSE.
NTSE.
Full stop. Provisional results were declared. Full stop. A decision was taken to the effect that the marks secured in the language test, into bracket English, right?
English.
In the English language test,
English.
would be treated only for the purpose of qualification. Full stop. The first and second respondents did not qualify at the examination. Full stop. However, they obtained information under the Right to Information Act, in pursuance of which they were intimated that the marks which were scored in the language test were not taken into account in the final selection. Full stop. They instituted a writ petition before the Rajasthan High Court. Full stop. Their contention was that they were aggrieved by the decision to treat the language test only for the purpose of qualification, as distinguished from merit.
Account for the.
Only क्या लिखा? They were aggrieved by the language test being treated only as a qualifying test, and not for computing the merit, the aggregate marks in the preparation of the merit list. Full stop. It appears during the course of the submissions of the petitioners that the decision to treat the language test only for qualification was taken by a high-powered committee, which acted upon
That's the only committee. not high-
high-powered by a committee,
By a committee.
following representations which were received from students, particularly with a rural background, particularly on the basis of representations received from students that
Students, the guardian, not, because students are
the
minor.
representations received on behalf of students to the effect that treating the language test of English for the purpose of computing the merit list would cause serious prejudice to students, particularly from a rural background. Full stop. The single judge of the High Court allowed the petition under Article 226 and directed the petitioners to determine the merit of the first and second respondents afresh after considering the marks which were scored in the language test. Full stop. This decision was taken on the basis of the judgment of this court in K. Manjushri versus State of Andhra Pradesh, 2008, 3 SCC 512. Full stop. The writ appeal was dismissed by the division bench. Full stop. While on 12 February 2018, notice was issued in these proceedings under Article 136 of the Constitution, and the contempt proceedings which were initiated before the High Court were stayed. Full stop. Tag किया होगा. Hearing the proceedings have been tagged together with Civil Appeal 2634 of 2013. 2634 is that Yes,
Your Lordship.
into brackets, Tej Prakash Pathak versus Rajasthan High Court,
That is the main petition.
in which a reference has been made to the Constitution bench on the basic issue, as to whether the rules of the game can be changed midway after the selection process has been initiated. Full stop. In the present case, despite service, none has appeared on behalf of the first and second respondents. Full stop. We are not inclined to go into the broader question which was raised on the reference to the Constitution bench and the facts of the present case. Full stop. The judgment of the single judge would result, learned counsel appearing on behalf of the petitioner submitted that the judgment of the learned single judge would result in a situation where the entire result would have to be redone, since a conscious decision was taken in the interest of the students not to treat the language test as a merit-based test, but only for the purpose of qualification. Full stop. If the judgment of the single judge were to be upheld, as has been done by the division bench, the result would have to be recast at this point in time, nearly 8 years after the examination has been concluded. Full stop. In the meantime, following the declaration of the results, the National Talent Search, the scholarship following the National Talent Search examination has already been awarded to a large number of students situated all over the country. Full stop. In this backdrop, and without this court expressing any opinion on the broader question of law which was sought to be raised, we are of the considered opinion that it would be appropriate to set aside the interim judgment of the High Court, which we accordingly do. Full stop. The petition likhana humne, the appeal shall leave granted. The appeal shall stand disposed of in the above terms. All right, now let us see Tej Prakash Pathak. Where is the judgment? Just show us from the compilation.
Lord,
It's
it's on page number
Vijay, I'm sorry.
210.
if your lordship can see
compilation.
the Mr. Hansaria's volume 1 compilation, that would be at PDF page 212,
Volume 1, right?
volume 1.
Volume 1, 212.
PDF page 212.
All right. Yes.
Lordship, please come to para number 10, first 10. Under the scheme of our constitution, an absolute and non-negotiable prohibition against retrospective lawmaking is made only with reference to the creation of crimes. Any other legal right or obligation could be created, altered, or extinguished retrospectively by the sovereign lawmaking bodies.
Just a minute. PDF page, give me the page again.
To PDF 212 starts.
All right.
He's reading at 216.
All right, all right.
Right, running page 214.
214.
PDF page 216.
However, such drastic power is
Wait a minute.
para 10. However, such drastic power is required to be exercised
Higher now.
Para 10, no?
Para 10. The scheme of our constitution and absolute and non-negotiable prohibition against retrospective lawmaking is made only with reference to the creation of crimes. Any other legal right or obligation would be created, altered, extinguished retrospectively by the sovereign lawmaker. However, such drastic power is required to be exercised in a manner that it does not conflict with any other constitutionally guaranteed rights such as Article 14 and 16, etc. Changing the rule of game, either midstream or after the game is played, is an aspect of retrospective lawmaking power. Various cases deal with the situation where the state sought to alter the eligibility criteria of the candidate seeking employment or the method and manner of making selection of the suitable candidate. The latter could be termed as a procedure adopted for the selection, such as prescribing minimum cutoff marks to be secured by the candidates, either in the written examination or viva voce, Mr. Dunning Manjushri, or the present case for calling upon the candidates to undergo some tests relevant to the nature of the employment, such as driving test abroad. If the principle of Manjushri case is applied strictly to the present case, the respondent High Court is bound to recruit 13 of the best candidates out of 21 who applied irrespective of their performance in the examination held. In such cases, theoretically, it is possible that candidates securing very low marks but higher than some other competing candidates may have to be appointed. In our opinion, application of the principle as laid down in Manjushri case without any further scrutiny would not be in the larger public interest, but the goal be establishing an efficient administrative machinery. This court in state of Haryana and Subhash Chandra Marwa, while dealing with the recruitment of subordinate judges of the Punjab Civil Services, had to deal with the situation where the relevant rule prescribed minimum qualifying marks. The recruitment was for filling up of 15 vacancies, 40 candidates secured the minimum qualifying marks, 45%. Only 7 candidates who secured 55% and above marks were appointed, and the remaining vacancies were kept unfilled. The decision of the state government not to fill up remaining vacancies in spite of availability of candidates who secured the minimum qualifying marks was challenged. The state government defended its decision not to fill up posts on the ground that the decision was taken to maintain the high standards of competence in judicial service. The High Court upheld the challenge and issued a mandamus. In appeal, this court reversed and opined that the candidates securing minimum qualifying marks at an examination held for the purpose of recruitment into the service of the state have no legal right to be appointed. In the context it was held. In a case where appointments are made by selection from a number of eligible candidates, it is open to the government with a view to maintain high standards of competence to fix a score which is much higher than one required for more eligibility. Unfortunately, the decision in Subhash Chandra Marwa does not appear to have been brought to the notice of the lordships in Manjushri. This court in Manjushri relied upon P.K. Ramchandra Iyer and Univa versus Union of India, Umesh Chandra Shukla versus Union of India, and Durga Charan Mishra versus State of Orissa. In none of the cases was a decision in Subhash Chandra Marwa considered. No doubt it is salutary principle not to permit the state or its instrumentalities to tinker with the rules of the game. Insofar as the prescription of eligibility criteria is concerned, as was done in Channa Swami versus State of Mysore, Channa Vasavaiya versus State of Mysore, etc., in order to avoid manipulation of the recruitment process and its result. Whether such a principle should be applied in the context of the rules of the game, stipulating the procedure for the selection, more particularly when the change sought is to impose a more rigorous scrutiny for selection requires an authoritative pronouncement of a larger bench of this court. We therefore order that the matter be placed before the Honorable Chief Justice of India for appropriate orders in this regard.
Yes.
Lordship, now the para number 27, also I want to read from Manjushri.
All right. What page is Manjushri in this compilation?
167 of the same compilation.
How much?
167, PDF page 167.
167.
167, para number 27.
Starts at 160.
But what could not have been
We
done?
see Marwa before that, or you want to see? Oh, well, right. We see Manjushri, and then we'll.
First Manjushri. Lordship. But what could not have been? Para 27.
One second. Let's see the facts of Manjushri for a second.
Para 2, Lordship.
Yes.
Para 2 Lodge. Selection and appointments to the post of district and session judge are governed by the Andhra Pradesh State Higher Judicial Services Rule 1958. The said rules provide that 1/3 of the total number of permanent posts of district and session judge should be filled by direct recruitment. It also prescribes the qualifications for appointment but does not prescribe any procedure for selection. As the rules only prescribe the qualification for appointment but did not lay down the selection procedure. The manner and method of selection is decided by the High Court. For every selection, as and when the vacancies are notified for selection, the government of Andhra Pradesh is issued an advertisement dated 28/5/2004 inviting applications for appointment to the following 10 posts of district and session judge. Now, Lordship, para number 4. The full court of Andhra Pradesh High Court has authorized the Chief Justice to constitute committees for the convenience of administration. The resolution of the full court containing the guidelines relating to the functioning of the High Court have been compiled in the form of standing orders. 2.13 enumerates the matters to be dealt by the full court. SO 2.14 enumerates the matter to be dealt with the administrative committee. Recruitment of district judges is a matter to be dealt by the administrative committee under SO 2.14. The decision minutes of the administrative committee in regard to the recruitment of district judges are therefore placed before the full court for its consideration under SO 2.13. The administrative committee, by its resolution dated 30/11/2004, decided the method and manner of selection. It resolved to conduct the written examination for the candidates for 75 marks and oral examination for 25 marks. It also resolved that the minimum qualifying marks for the OC, BC, SC and ST candidates shall be prescribed earlier. As per its direction, the written examination was held on 30/1/2005 and 1026 candidates appeared for the examination. The results were declared on 24/2/2005 and 83 candidates were successful in the written examination. Due to the pendency of the litigation, interviews could not be held immediately. A committee of 5 judges was constituted for interviewing the candidates and interviews were held in March 2006. Thereafter, the marks obtained by 83 candidates in the written examination and in the interview were aggregated and the consolidated merit list of the 83 candidates was prepared in the order of the merit on the basis of aggregate marks. It contained the registration number, the name of the candidates, reservation category, marks secured in the written examination out of 100 marks, marks secured in the interview out of 25 marks, and the total marks secured in the written examination and interview out of 125. Thereafter, 5 more merits list in respect of categories BCA, BCB, BCD. Committee finalized the following list of candidates to be recommended for appointment as per merit and reservation and submitted to the administrative committee with a report dated 3/4/2006. Now, para number 8, Lordship. The full court considered the resolution of administrative committee dated 30/11/2004 and 4/4/2006 and the record of selection. The full court impliedly approved the resolution dated 30/11/2004, but it did not agree with the selection list prepared by the interview committee and approved by the administrative committee by resolution dated 4/4/2006. The full court authorized the Chief Justice to constitute a committee of judges for preparing a fresh list of candidates to be recommended for appointment of district and session judges. Accordingly, the Chief Justice appointed a subcommittee of 2 judges on 7/4/2006. The said subcommittee was of the view that the candidates should be evaluated with the reference to written examination, marks of 75, interviews marks of 25 as per the resolution dated 30/11/2004, instead of being evaluated with the reference to written examination, marks of 100 and interviews of 25, thereby varying the prescribed ratio between written examination marks and interview marks from 3:1 to 4:1. Therefore, it scaled down the marks obtained by the candidates in the written examination with reference to a total of 100 in proportion to a maximum marks of 75. By adding the interview marks of 25, the total marks obtained by candidates with reference
Go ahead.
Yes.
to a total of 100 were recalculated. The subcommittee was also of the view that apart from applying the minimum marks for the written examination for determining the eligibility of the candidates to appear in interview, the same cutoff percentage should be applied for interview marks. And those who fail to secure such minimum marks in the interview should be considered as having failed. As the minimum percentage for passing the written examination for 50% for open category, 40% for backward classes and 35% for ST/SC, only those candidates who secured minimum of 12.5 marks, 10 marks, 8.75 marks, were considered as having succeeded in the interview. Consequently, only 31 candidates were found to have qualified both in written examination and interview, and a revised merit list was prepared, pruned down to 31 successful candidates. On that basis, 9 candidates were recommended for appointment as under. One vacancy relating to scheduled caste women was left unfilled as there was no qualified candidate. The said report and the selection list was considered by the full court on 28/4/2006, and it was resolved to accept the names of the aforesaid 9 candidates in the said list to the state government for appointment. The second list contains the names of 5 out of 10 candidates recommended in the first list, 2, 4, 6, 8, 10 in the first list, 1, 3, 4, 7, 9 in second list, and 5 candidates in the first list, 1, 3, 5, 7, and 9 in the first list got eliminated as they failed to secure the minimum marks in the interview, and 4 fresh candidates entered in the second list. No candidate was selected under the category of SC women, as no candidate for that category secured the minimum marks in the interview. 2 of the candidates whose name were found in the first list and who got excluded in the second list, namely K. Manjushri, filed writ petition 10061 and 10062 of 2006 in High Court, praying for a declaration that the action of the High Court in preparing the selection list by prescribing minimum qualifying marks for the interview was arbitrary and illegal, seeking a direction to the High Court to redraw the selection list without adopting minimum qualifying marks for the interview. The said writ petitions were dismissed by the High Court by a common judgment dated 30/10/2006. This appeal is by K. Manjushri, whose name was found in the first list. She contended that the minimum marks.
You can skip all that contention.
Para-
The issues we can
17.
go to paragraph
17. I'll just read 17. Issues are on the contingents urged the following questions arise for consideration. What was the procedure, method and manner of selection prescribed by the administrative committee for filling the post advertised on 28/5/2004, whether the list prepared by the interview committee and approved by the administrative committee suffered from any error, irregularity and illegality. Third point, whether the procedure adopted by the full court in preparing the fresh selection list by applying the requirement of minimum marks for interview also is legal and valid. The rules did not prescribe any procedure for selection. When the posts were advertised, the only criteria for selection that was mentioned was that the selection will be done by holding written.
Question 1, you can go straight to question 3, I think.
Yeah.
Right, question 3.
Yes, Lordship.
That you will get it.
It's important, the manner of holding written examinations and interviews. The marks for written examination and interview, whether the candidate should secure any minimum marks in the written examination or interview, were all yet to be decided. As per the practice followed by the High Court, the entire process of recruitment of district judge was to be dealt with the administrative committee, and the decision of the administrative committee were placed before the full court for its consideration and approval. The administrative committee at its meeting held on 30/11/2004 considered the method and manner of recruitment to the adopted in regard to the said recruitment and took the following 3 decisions: that the written examination will be held on 31/2005 simultaneously at 4 centers, that the marks for the written examination shall be 75 and for oral examination 25. That the minimum qualifying marks for OC, BC, SC and ST shall be prescribed earlier. The 2 decisions are self-contained and clear. In regard to the third decision, it becomes necessary to ascertain what were the minimum qualifying marks for OC, BC, SC and ST, which had been prescribed earlier. There were no general prescription of guidelines or norms or criteria for holding the written examination and interviews marks therefore. The procedure to be applied in regard to each recruitment was laid down separately by the administrative committee as and when the recruitment was done. When the administrative committee decided on 30/11/2004 that the minimum qualifying marks for OC, BC, SC and ST shall be prescribed earlier, it obviously referred to what was prescribed when the previous recruitment was made in 2001 and 2. The High Court has produced the relevant minutes relating to earlier recruitment. It is seen that the administrative committee had laid down the following method and manner for recruitment to 6 posts of district and session judge. Its resolution dated 24/7/2001. Considered and resolved that the mode of examination be by way of written test for 75 marks and oral 25 marks, and the minimum qualifying marks for open categories 50 marks and for other categories of 40 marks and 35 marks. Written examination in the same ratio will be applied for the oral interview also. The minimum qualifying marks for the written examination was subsequently amended, corrected by administrative committee at its meeting held on 21/2/2002 as follows. Considered and resolved to correct the typographical error occurred in the resolution of administrative committee meeting held on 24/7/2001 mentioning 50 marks, 40 marks and 35 marks instead of 50%, 40% and 35%. That is the minimum qualifying marks for open category is 50% for backward, 40% and scheduled tribe, 35% in the written examination. Let us to try to analyze and find out the combined effect of the resolution 24/7/2001, 21/2/2002. The resolution dated 24/7/2001 prescribed the following marks for the written examination and the interview. The marks for the written examination was 75 marks and the minimum qualifying marks was 50 marks for open category, 40 marks for the backward classes and 35 marks for scheduled tribes.
Twenty-five and twenty-seven.
25, Lordship. 25, I will now read, Lordship. When the administrative committee placed a merit list and selection list before the full court, apparently objections were raised on two grounds. One related to failure to provide the minimum 50%, 40% and 35% marks for interviews on the interpretation of resolution dated 30/11/2004, read with earlier resolutions dated 24/7/2001 and 2002. The second objection was that even though the administrative committee had resolved that the marks for written examination should be 75 and interviews would be 25 at the time of tabulating the marks secured out of 100 marks in the written examination had been taken into account without scaling it down with the reference to a maximum of 75 marks. The full court therefore appointed a subcommittee of 2 judges to examine the matter and prepare a fresh merit list and selection list. The subcommittee examined the matter and submitted a revised merit list by incorporating 2 changes. Firstly, while tabulating the marks, it scaled down the marks secured by the candidates in the written examination with reference to a maximum of 100 marks in proportion to a maximum of 75 marks, so that the final marks were with the reference to a base of 75 marks for written examination and 25 marks for interview as resolved on 30/11/2004. Secondly, it applied the minimum percentage of 50%, 40%, 35% for OC, BC, SC and ST even in regard to interviews, and consequently eliminated those who secured less than minimum in the interview. From the process of selection, the final selection list was prepared with a reference to the fresh merit list prepared by incorporating the said 2 changes. As far as the first change is concerned, we have already held that a scaling down is unexceptional as it is consistent with the criteria decided by the administrative committee on 30/11/2004 before commencing the selection process. But what could not have been done was the second change by introduction of the criteria of minimum marks for the interview. The minimum marks for interview had never been adopted by the Andhra Pradesh High Court. Earlier, for the selection of district and session judge, in regard to present selection, Administrative Committee merely adopted the previous procedure invoked. The previous procedure as stated above was to apply minimum marks only for written examination and not for the oral examination. We have referred to the proper interpretation of the earlier resolution dated 24/7/2001, 21/2/2002 and held that what was adopted on 30/11/2000 was only minimum marks for written examination and not for interviews. Therefore, introduction of the requirement of minimum marks for interview after the entire selection process was completed would amount to changing the rules of the game after the game was played, which is clearly impermissible. We are fortified in this view by several decisions of this court. It is sufficient to refer three of them: P.K. Ramchandran Iyer versus Union of India, Umeshchan Shukla versus Union of India, and Durgacharan Mishra versus State of Orissa. In Ramchandra Iyer, this court was considering the validity of a selection process under the ICAR Rules 1977, which provided for minimum marks only in the written examination and did not envisage obtaining a minimum marks in the interview. But the recruitment board prescribed a further qualification of obtaining minimum marks in the interview also. This court observed that the power to prescribe minimum marks in the interview should be explicit and cannot be read by implication for the obvious reason that such deviation from the rules is likely to cause irreparable and irreversible harm. This court held that as there was no power under the rules for the selection board to prescribe the additional qualification of securing minimum marks in the interview, the restriction was impermissible and a direct impact on the merit list, because the merit list was to be prepared according to the aggregate marks obtained by the candidates at written test and interview. Once an additional qualification of obtaining minimum marks at the Viva Voice test is added to candidate who may figure high up the merit list, was likely to be rejected on the ground that he has not obtained minimum qualifying marks at the Viva Voice test. To illustrate, candidate who has obtained 400 marks at the written test and obtained 38 marks at the Viva Voice test, it considered on the aggregate of marks being 438 was likely to come within the zone of selection, but what would be eliminated by ASRB on the ground that he has not obtained qualifying marks at Viva Voice test. This was the impermissible and contrary to rules, and the merit list prepared in the contravention of rules cannot be sustained. In Umesh Chandra, the score of Delhi Judicial Services Rules 1970 came up for the consideration. The rules provided those who secured the prescribed minimum qualifying marks in the written examination will be called for Viva Voice, and that the marks obtained in the Viva Voice shall be added to the marks obtained in the written test, and candidates' ranking shall depend on the aggregate of both. 27 candidates were found eligible for appear for a Viva Voice on the basis of their having secured the minimum prescribed marks in the written examination. The final list was therefore expected to be prepared by merely adding a Viva Voice marks to be written examination marks in regard to those 27 candidates. But the final list that was prepared contained some new names which were not in the list of 27 candidates who passed the written examination. Some names were omitted from the list of 27 candidates who passed the written examination. It was found that the selection committee had moderated the written examination marks by addition of 2% for all candidates, as a result of which candidates who did not get through the written examination became eligible for Viva Voice and came into the list. Secondly, the selection committee prescribed for selection and a minimum aggregate of 600 marks in the written examination and Viva Voice, which was not provided in the rules, and that resulted some of the names in the list of 27 candidates being omitted. This court held neither was permissible dealing with the prescription of minimum 600 marks in the aggregate the court observed. There is no power reserved under Rule 18 of the rules for the High Court to fix its own minimum marks in order to include candidates in the final list. It is stated in para 7 of the counter affidavit filed in writ petition that the selection committee has inherent power to select candidates who according to it are suitable for appointment by prescribing minimum marks.
three actually, because then he refers to one more judgment and then goes to para 33.
Lordship, 32 also.
All right.
In Maharashtra, SRTC and Rajendra Bhimrao Mandve, this court observed that the rules of the game, meaning by thereby that the criteria for the selection cannot be altered by the authorities concerned in the middle or after the process of selection has commenced. In this case, the position is much more serious. Here, not only the rules of the game were changed, but they were changed after the game had been played and the results of the game were being awaited. That is unacceptable and impermissible. In 2004, merely adopted the procedure prescribed earlier. The previous procedure was not to have any minimum marks for interview. Therefore, extending the minimum marks prescribed for written examination to interviews in the selection process is impermissible. We may clarify that the prescription of minimum marks for any interview is not illegal. We have no doubt that the authority making rules regulating the selection can prescribe by rules the minimum marks both for written examination and interviews or prescribe minimum marks for written examination but not for interview, or may not prescribe any minimum marks for either written examination or interview. Where the rules do not prescribe any procedure, the selection committee may also prescribe the minimum marks as stated above. But if the selection committee wants to prescribe minimum marks for interview, it should do so before the commencement of the selection process. If the selection committee prescribe minimum marks only for written examination before the commencement of selection process, it cannot either during the selection process or after the selection process add an additional requirement that the candidates should also secure minimum marks in the interview. What we have found to be illegal
Now seen,
we'll
come back. We'll come back after lunch. After this, we will look at Marwa, and then you can make your submissions on it. And then we'll hear what all of you have to say.
Lordship, there's a small request.
Yes.
Lordship, one. Our hands are freezing.
Should we raise the temperature otherwise?
Then your Lordship's court are full of lawyers. Currently,
Yes. The reason why the temperature is low is that all the lawyers on the first row right now are all the calm ones, you know. You see, you don't have any. True.
33 page, 33 parent. The resolution dated 30/11/2004 merely adopted the procedure prescribed earlier. The previous procedure was not to have any minimum marks for interview. Therefore, extending the minimum marks prescribed for written examinations to interviews in the section process is impermissible. We may clarify that the prescription of minimum marks for any interview is not illegal. We have no doubt that the authority making rules regulating the selection can prescribe by rules the minimum marks both for written examination and interviews, or prescribe minimum marks for written examination but not for interview, or may not prescribe any minimum marks for either written examination or interview. Where the rules do not prescribe any procedure, the selection committee may also prescribe the minimum marks as stated above. But if the selection committee wants to prescribe minimum marks for interview, it should do so before the commencement of the selection process. If the selection committee prescribe minimum marks only for the written examination before the commencement of selection process, it cannot either during the selection process or after the selection process, and add an additional requirement that the candidate should also secure minimum marks in the interview. What we have found to be illegal is changing the criteria after completion of the selection process when the entire selection proceeded on the basis that there will be no minimum marks for the interview. It was submitted that administrative committee and interview committee were only delegate of the full court, and the full court has the absolute power to determine or to regulate the process of selection, and is also the power and authority to modify the decisions of the administrative committee. There can be no doubt about the proposition that the administrative committee, being only a delegate of the full court, all decisions and resolutions of administrative committee are placed before the full court for its approval, and the full court may approve, modify, or reverse any decision of the administrative committee. For example, when the resolution...
That's all right. That's not really on, that's not very relevant, isn't it? Oh, no, that's it.
36.
Then we will see the
36 paragraph.
36.
The full court, however, introduced a new requirement as to minimum marks in the interview by the interpreted process, which is not warranted and which is at variance with the interpretation adopted while implementing the current selection process and the earlier selections. As the full court approved the resolution dated 30/11/2004 of the administrative committee and also decided to retain the entire process of selection consisting of written examination and interviews, it could not have introduced a new requirement of minimum marks in interviews, which had the effect of eliminating candidates who would otherwise be eligible and suitable for selection. Therefore, we hold that the action of the full court in revising the merit list by adopting a minimum percentage of marks for interview was impermissible. The divination bench of the High Court, while considering the validity of the second list, has completely missed this aspect of the matter. It has proceeded on an erroneous assumption that the resolution dated 30/11/2004 of the Administrative Committee prescribed minimum marks for interviews. Consequently, it erroneously held that the Administrative Committee had acted contrary to its own resolution dated 30/11/2004, not excluding candidates who had not secured the minimum marks in the interview, and that the full court had merely corrected the wrong action of the Administrative Committee by drawing up the revised merit list by applying marks for the interview also. The decision of the division bench therefore cannot be sustained. Conclusion, that we therefore find that the judgment of the division bench of the High Court has been
Right, that's fair enough.
Lordship.
Now let's look at the other judgment.
Lordship, Marwa Lordship.
First judgment of the
First volume.
first volume, the same volume, Lordship. First judgment.
First judgment, Lordship. Page number 1. para number 2. An advertisement was published in Government Gazette to the effect that the Haryana Public Service Commission will hold an examination for recruitment of candidates for 15 vacancies in Haryana Civil Services Judicial Branch. In response to the advertisement, a number of candidates appeared for the examination held in November 1970. The result of the competitive examination were declared and published in the Haryana Government Gazette on April 6, 1971. It was a list of 40 candidates who obtained 45% or more marks in the examination. The state government, which is appointing authority, made 7 appointments in the serial order of the listing according to the merit. Respondents who ranked 8, 9, and 13 respectively in the list did not get an order of appointment, although there were vacancies. The reason for not making the appointment was that in the view of the state government, which was the same as that of the High Court previously intimated to the state government, candidates getting less than 55% of marks in the examination should be appointed as subordinate judges in the interest of maintaining high standards of competence in judicial services. Respondent number 1 to 3 have expected to be appointed filed a petition claiming that since there were 15 vacancies and they had the necessary qualifications for appointment of the state government, was not entitled to pick and choose only 7 out of them for appointment, because to do so would be the prescriber standard, which was not contemplated by the rule that but was against them. The appellant, on the other hand, contended that the rules did not oblige them to fill in all the vacancies and it was open to them to appoint the first 7 candidates from the list in the interest of maintaining high standards. There was no question of picking and choosing. The rules did not prevent the state from deciding at the time of selection from the list the minimum number of marks that a selected candidate should score for the purpose of an appointment. The High Court agreed from the contention of the state that merely because of the advertisement was for filling 15 vacancies, the first 15 candidates in the list had no right to be appointed in the post, but held that as long qualified candidates were available, those candidates had a legal right to be selected under Rule 10 or Part C in the rule. In the view of the High Court, the state government was not entitled to impose a new standard of 55% of marks for selection, as that was against the rule which provided for a minimum of 45%. It is contended on behalf of the appellant that the above finding against the state was erroneous. The submission was that under the rules, the minimum of 45% was an element to be considered for the eligibility of a candidate for selection, and that while making the actual appointment by selection, the state government, in the interest of maintaining high standards of judicial competence, were not prevented from fixing a minimum standard of a score of 55% marks, especially as that was the view of the High Court also previously intimated to them. In our views, the submission is correct. Elaborate rules were framed by the Punjab government in 1951 for the purpose of recruitment of subordinate judges to the Punjab Civil Services. After the bifurcation of the Punjab state, these rules applied to the state of Haryana, and the same have been published by the government of Haryana with appropriate amendments. Part A of these rules deal with general qualification, and B deals with preparation and submission of roles for those who are qualified in the Part A. Those who are on those roles prepared by the district judges become eligible for appearing in a written examination held by the Punjab Public Service Commission. The rules with regard to the examination are in Part C. Rule 4 thereof provides the examination papers shall be set and marks awarded by examinees who will be appointed by the Punjab Service Commission. Rule 8, which is important, it is as follows. No candidate shall be considered to have qualified unless he obtains 45% marks in the aggregate of all the papers and at least 33% marks in the language paper, that is Hindi. As we shall see immediately, and final selection depends entirely on this examination. Apart from this examination, there is no other hurdle except that of medical examination to be passed by the candidate. No oral interviews prescribed in 10 as follows. The result of the examination will be published in the Punjab government. It will be seen from this that the function under the rules given to the Punjab Public Service Commission was to hold the examination and then prepare a list strictly in accordance with merit on the basis of the marks received in the examination, and the list was to be published in the Punjab Government Gazette. That is, became the public property, and every candidate would know, having regard to the vacancy, whether he is likely to be appointed. The list is of great importance. There could be no departure from the list either by the Public Service Commission, the High Court, or the state government. This will be seen from Part D, which relates to appointments. Rule 1 in this part provides that the names of the candidates selected by the government for appointment as subordinate judges under Rule 10 and 11 Part C shall be entered on the High Court register in order of their selection. Rule 10(2) in Part C referred to earlier stated that the candidates will be selected for appointment, and Rule 1 in the Part D says that the selection was by government for appointment. Reading the two together, it is clear that the government was bound to take the selection strictly in the order in which the names were mentioned by the Public Service Commission in the list. And this selection was for the specific purpose of the making appointments. There is no question of the High Court making any recommendations. Once accordance with the list, such selection for appointment is limited to the High Court, and the candidates who selected by the government for appointment are to be entered by the High Court in a register in the order of the selection. Obviously, the register is to be kept by the High Court because the High Court knows in the administrative capacity what vacancies have occurred and what are the courts to which the appointments have to be made. The service rules have been made in the consultation with the Public Service Commission and the High Court, and therefore they are binding on all. They show that examination is a final test, apart from medical examination as per Rule 11 in Part C, for a candidate's appointment to the post of the subordinate judges, and once the list is prepared by the Public Service Commission, strictly in order of the merit, neither the Public Service Commission nor the state nor the High Court can depart from the order of the merit given in the list, except where reservations have been made in favor of backward classes and scheduled castes and tribes in according with Rule 10. In the present case, it appears that about 40 candidates have passed examination with a minimum score of 45%. Their names were published in the Government Gazette as required by Rule 10(1), already referred to. It is not disputed that the mere entry in this list of the name of the candidate does not give him the right to be appointed. The advertisement that there are 15 vacancies to be filled does not also give him a right to be appointed. It may happen that the government, for financial or other administrative reasons, may not fill up any vacancy. In such a case, the candidates, even the first in the list, will not have a right to be appointed. The list is merely to help the state government in making the appointments, showing that candidates have the minimum qualification under the rules. The stage for the selection for appointment comes thereafter. And it is not disputed that under the Constitution, it is the state government alone which can take the appointments. The High Court does not come into the picture of recommending any particular candidate after the state government have taken a decision as to which of the candidates in accordance with the list should be appointed. The list of the selected candidates for appointment is forwarded to High Court, and then we'll have to enter such candidates on a register maintained by it. When vacancies are to be filled with the High Court, will send in the names of the candidates in accordance with the selected list and in the order they have been placed in that list for appointment in the vacancies.
Placement in
The High Court.
That you are placed in a select list doesn't give a right to appointment.
Yes.
And you can't seek a mandamus on that basis. And then paragraph 12, they say that
They say that 45%, that's a correct.
at page 220, internal page 8, in a case where appointments, fourth line, are made for selection from a number of eligible candidates, it is open to the government with a view to maintain higher standards of competence to fix a score which is much higher than the one required for eligibility. As shown in the letter of the Chief Secretary already referred to, they fixed a minimum of 55% for selection, as they had done on a previous occasion. There is nothing arbitrary in fixing the score of 55% for the purpose of selection, because that is the view of the High Court also previously intimated. Exactly, this is what we are saying. Discuss of freedom there. Merely because all the people who are in the select list or a number of people in the select list fall within the number of vacancies which are advertised would not give a vested right to everyone in the select list within the number of vacancies to claim appointment. The state can carry out an exercise of shortlisting. They can shortlist it for two purposes. A, where the number of candidates is unusually large, but they can also carry out a shortlisting to maintain the standards of competence and efficiency in the service.
And this action doesn't. The merit lists. Yes, that's the distinction.
No, more than the merit list, it will not have a bearing on a right.
Right.
Yes.
Right.
Because till that point of time, there is no right.
But here, when we talk about
And
this.
this does not amount to a change of the rules of the game.
That obviously.
Correct.
And therefore, there is no conflict in terms of Manjushri.
Actually, Marwa's case and Manjushri's case stand on a completely
Yes,
different footing.
Yes.
Marwa's case, what happened was, there were X number of vacancies. Then a select list was prepared
On 45%.
on 45%, because the eligibility was pegged at 45%. But among those who appeared in the select list, the government decided to take only those people who are above 55%. That is all.
That is.
Manjushri's case had a problem because the principle of allocating minimum cutoff mark
For the interview.
for the interview operated to impose a condition of eligibility
Yes.
by a subsequent act, subsequent to the process which was initiated. So really Manjushri's case seems to indicate that you cannot introduce a new condition of eligibility in the selection process,
Disturbs the merit list.
which disturbs the merit list. But Marwa's case indicates that once the select list is, even though the select list has been, before the select list is prepared and you have a merit list of candidates, you can certainly carry out a process of shortlisting. You may also say that, well, we will not take anybody below this particular mark position, the cutoff, when we make final appointments. So there is no conflict between the two.
Yes.
Because in Marwa's case, they did not introduce a condition of eligibility. Everybody was eligible. But they said we will take only up to those who have scored 55% or more. In Manjushri's case, the effect was that you excluded people in the interview, excluded completely from the select list people who did not have more than the cutoff marks in the interview. So though they may have had higher aggregate marks, they were excluded because that operated as a condition of eligibility.
Generally, lordships in all judgments have interfered only at the stage when there is an introduction in the interview. Even in the cases of, there's no.
So the question will arise as to what would apply in Tej Prakash's reference case.
Yes.
So in Tej Prakash's reference case is that after the advertisement was issued and written test also happened,
The list was drawn.
then they said 70%, 75%
And above.
and above should be
Yes.
kept. So it's identical as that of
Yes.
Marwa,
Yes.
as well as the case of the other case, which the Umesh Chandra. It is not similar to that of
No, but the
Manjushri.
question problem arises, Umesh Chandra is in conflict with Marwaha. That is the problem, because para 27 of Manjushri
We haven't
endorses
seen
Umesh
Umesh
Chandra.
Chandra. But Umesh Chandra, as it is
Again,
mentioned and referred to by Justice Ravindran in Manjushri,
Yes, it is para 20,
talks about 29,
Yes.
para 21.
yes, 27 he endorses it and thereafter he extracts it at para 29 to onwards. But
So, but then that's again, that stands on the same footing as that of Marwa.
And
in
but then in
but there
deferred
is
judgment
conflict.
again.
Actually, Tej Prakash stands on all fours with Marwa.
Exactly.
Because what they did was that, though in the past, of course, in the past, that bar of, that not bar, the requirement of 75% had been removed. What they did here was, after the Viva was held, they said we will not take anybody below 75% in the aggregate.
Yes,
So that was Marwa.
yes.
It did not operate as a condition of eligibility, but they said that, look, condition of eligibility means that if you don't score that amount, namely say 50% or 55%, you will not be looked at for the next round at all. You will be closed at the threshold. So unless you score 55% in the, say 45% in the interview, your score will not be looked at all. You are ousted from the competition.
Actually, in Tej Prakash, the matter was justified following Marwa.
Marwa.
But in the reference order, they assumed that it was covered by
The
Manjushri,
Yes.
and that in Manjushri they forgot to refer to Marwa.
Marwa.
So therefore refer to 5.
In fact,
And
Lord-
Manjushri is
Manjushri
completely distinct. Both are completely on different.
Manjushri endorses Umesh Chandra. So one will have to say that even Umesh Chandra is different from Marwa.
That's all right. I mean, those nitty-gritties, just because he has referred to, it's all right. But the principle
Now,
is very, very clear.
and what is Umesh Chandra actually?
Your Lordship,
Let's see Umesh.
Let's see just quickly, let's see Umesh Chandra.
Yes, Your Lordship.
See Manjushri.
It's a
Manjushri's page 160.
volume compilation to
Umesh
page
Chandra.
51. PDF page 51. Yes, page 51, volume 2.
Yes.
PDF page,
51.
51.
same volume.
Yes, Your
No,
Lordship.
what's the volume?
Volume 2, sorry.
Umesh and Shukla's judgments is there.
What page is that? 51, I think.
49.
Para number 49 is well.
49, 51. What are the facts? One second, कौन से page से शुरू होता
Yes.
है?
Your Lordship will see, para 2,
PDF 50.
para 2, 6, 7 are the
Volume
facts
2
in
चाहिए.
Umesh Chandra.
Volume 2 क्या?
Yeah, volume 2.
Volume 2, Your Lordships, I
तो
think
मेरे
it's
पास भी तो यार
page
अनुकूल है.
49 of.
51 है, next page देखिए.
अच्छा अच्छा. Yes, yes.
The facts that in paras 2, 6 and 7. Your Lordship will paragraph 2. The petitioners in the.
Just 1 second, help you.
Yes.
This is 1985.
3 SCC 721.
720.
Volume 2, page 51. Let's have a look at para 2 you were saying, right?
Yes, Your Lordships. 2, 6 and 7 set out the important facts.
Let's see that.
Yes, Your Lordships. The petitioners in the above petitions were applicants for the posts of subordinate judges in the Delhi Judicial Service. Recruitment to the Delhi Judicial Service is governed by the Delhi Judicial Service Rules 1970, made by the Lieutenant Governor of Delhi in exercise of the powers conferred by the proviso to Article 309 of the Constitution, read with Article 234 of the Constitution in consultation with the High Court of Delhi. The initial recruitment to the Delhi Judicial Service was made in accordance with Part 3 of the rules. Initial recruitment means the first recruitment and appointment made to the Delhi Judicial Service after the commencement of the rules. Any recruitment to the Delhi Judicial Services after the initial recruitment is required to be made in accordance with rules contained in Part 4. We are concerned in these cases mainly with rules 13 to 18 of the rules and the appendix attached thereto. Rule 13 of the rules provides that recruitment after initial recruitment shall be made on the basis of a competitive exam to be held by the High Court at such intervals as the administrator may, in consultation with the High Court, determine. The administrator is no other than the Lieutenant Governor of Delhi. The dates on which and the place at which the examination is to be held are required to be fixed by the administrator. Rule 14 prescribes a minimum qualification for a candidate which he should satisfy in order to be eligible to appear at the competitive exam. A candidate is eligible to appear at the exam if he is citizen of India, person practicing as an advocate in India, not more than 32 years of age on the first day of January following the date of commencement of the examination. Rule 15 of the rules provides that the syllabus for the examination and the fees shall be payable as detailed here and above. The examination includes the following subjects. I'm not reading that, Your Lordships, if the marks are also mentioned. Para 3. The first 5 papers are called written papers. In clauses 1 to 5 of the appendix, the topics or subjects of each of the written papers are set out. Viva voce. Only such candidates will be called for viva voce who have obtained 50% in each written paper and 60% in the aggregate, except in the case of candidates belonging to SC/ST, in whose case the qualifying marks will be 40% in each written paper and 50% in the aggregate. The marks obtained in the viva voce have to be added to the marks obtained in the written papers, and the candidate's rank depends on the aggregate of both. Rule 16 of the rules provides that after the written test, the High Court shall arrange the names of the candidates in the order of merit, and these names shall be sent to the selection committee. Constitution of the selection committee is described by Rule 5, and it says who the selection committee is. Thereafter, if Your Lordship will go to para 6.
Yes.
The foregoing is in brief the summary of the rules governing the recruitment of persons to the Delhi Judicial Service after the initial recruitment. On July 5th, 1984, a notification was published in the local newspapers by the Registrar of the Delhi High Court calling for applications from eligible persons for filling the posts in the Delhi Judicial Service. A large number of candidates who were eligible under the rules applied in response to the said notification. The examination in the written papers, that is ABCD, was held in October 1984. After the answer books at the written examination were valued, the names of 27 candidates who were eligible for the viva voce test under the rules That is, the candidates who had obtained not less than 50% in marks in each paper and not less than 60% aggregate, etc., was published on the notice board of the Delhi High Court in the early part of January 1985. The names of the said candidates were arranged in accordance with their roll numbers and not in the order of merit. The following are the list of 27 candidates. I'm not reading the names.
Interesting, some of them then
Yes.
became High Court judges also. I was just quickly looking at the names.
The names, many are familiar names.
Yes.
Para 7. These candidates. These candidates were admitted to the Viva Voce test by the selection committee. Before the final list of candidates was published by the selection committee as required by Rule 18 of the rules, the petitioners came to know that names of certain candidates whose names had not been included in the above list of 27 qualified candidates had been included in the final list by the selection committee, and that the names of certain candidates who had been interviewed by the selection committee had been omitted from the said final list. Immediately thereafter, the petitioners filed these petitions questioning the validity of the procedure adopted by the High Court and the selection committee in the preparation of the final list of selection successful candidates. It is not necessary to refer to all the allegations made in the petitions. We propose to deal with only two contentions raised by the petitioners, namely, one, whether it was open to High Court to include in the list prepared under Rule 16 of the rules names of candidates who had not secured the minimum marks prescribed in the rules for being eligible to appear at the Viva Voce, and whether it was open to the selection committee or the High Court to omit the names of certain candidates who had appeared at the Viva Voce from the final list. In order to appreciate the above contentions, it is necessary to set out what the Deputy Registrar of the Delhi High Court has stated in his counter affidavit filed on behalf of the High Court in answer to the allegations. The Lordship will see below the extract of the counter. They basically say the petitioner in any event has no right to maintain. This is not relevant, but if your Lordship will thereafter go to paragraph 9. What they essentially did, I'll actually read that, your Lordship will know what has actually happened. There were some moderation marks they included.
They added 2 marks.
They added 2 marks to many candidates who didn't make it to the first 27. That the High Court, Supreme Court eventually held, you can't moderate and add 2 marks. But the second condition is important. I will just read that as well in any event, your Lordships. The second condition is where they introduce a minimum of 600 aggregate in the exam to be qualified for the Viva Voce, which was originally not there. So originally, as the rule stood, you had to get an aggregate of 60% across all the subjects to be eligible for Viva Voce. Now they said that's not enough. Over and above that, you also have to get aggregate of 600 marks. So an additional requirement was made for you to become eligible to sit for the Viva Voce.
Yes.
So as far as the moderation was concerned, there was no dispute. I mean, they said that you could not have moderated. Thereafter, when they go into the question of, fixing these things at para 9, para 9, your Lordships, somewhere in the middle of the paragraph, actually, I'll read the whole thing. In reply to para 7 of the writ petition, it is admitted to be correct, that is, Yes. Para 9. In reply to para 7 of the writ petition, admitted to be correct that it is provided. Yes, Your Lordships. Para 14 is a ratio on the second point. First point we're not concerned with. Yes, Your Lordship. Yes, Your Lordships. So as far as those 2 points were concerned, Your Lordship, on the first point on moderation, the court at para 13 held that you could not have moderated. The second condition, which is increasing the marks to 600.
Yes.
So that the candidates who went for the interview, they didn't find their names in the list because now there was an additional cutoff of 600. That the court at paragraph 14
Yes.
has said that the prescription of the minimum of 600 marks in the aggregate by the selection committee as an additional requirement which the candidate has to satisfy amounts to an amendment to what is already prescribed in the appendix, and said that this change of rule you could not have done by prescribing a further requirement. You already said minimum 60%, you should have stuck with it. By now saying you need to get 600 marks in addition, you have prescribed an additional requirement and that is impermissible, and the selection process.
60% was prescribed there as in the written test, right?
A cutoff for Viva Voce.
That you must get at least 50% in each paper.
Yes.
And 60% in the written test in the aggregated,
Yes.
in the aggregate to be called for Viva Voce.
Yes.
And what the High Court did there was in addition to say that you must get 600 marks in the aggregate after the Viva Voce.
Yes.
So you must have 600 in the combined result of the written test and the Viva Voce,
Yes, Your Lordships.
which Justice Venkatraman's judgment says is not permissible.
Yes,
But this is exactly what is done in Marwa's case.
exactly. This is precisely what we say at para 27.
So really speaking, yeah, so
27 of Manjushri, which endorses Umesh Chandra. In effect, it is contrary to Subhash Marwa.
because you're right, you are maybe right there because here, this 600 marks which they put at the end was really to say that, well, anybody, it's a cutoff at the end.
Yes, at the end.
It's not an eligibility.
It's not an eligibility. So less than 600, I could not be appointed. And even as far as this is concerned.
And by affirming therefore Umesh Chandra,
Only thing is
the
that
3-judge bench therefore implicitly has taken a view which is contrary to Marwa. To my mind, actually, there was nothing wrong in the High Court doing this, you see.
they could have done that.
Because, I mean, just subject to hearing you, because they said, look, we are not taking anybody less than 600 marks in the aggregate. We want to maintain quality. We'll say that, okay, anybody gets less than 600 marks, sorry, we are not going to appoint you.
I think the what trouble.
They considered everybody. Everybody was made eligible to participate.
Yes.
They didn't introduce a new condition of eligibility, but they said we are going to keep the merit list, aggregate merit list up to 600. Anybody below 600 won't come into the service.
Yes, Your Lordship. No, no.
Point did they impose the requirement?
After the selection, after the exams.
Even in Marwa.
Marwa also.
Yes.
Like in Umesh Chandra.
Like in Tej Prakash.
Even in Umesh Chandra.
Yes, Your Lordship. Now, the question is not about the right to prescribe. The question and the problem, a stage, because that always adds an element of, because this honorable court, even in Renu Kumar's case, where my Lord Justice Narasimha was appointed as amicus, has said that all public selections should be transparent. All rules should be notified right in the beginning. When you make any changes, even if it appears to be something like increasing the criteria, it can lead to mischief. So the idea is to.
You know what? Then you can say that, well, you must demonstrate that this is arbitrary then. By merely putting a cutoff, by merely putting a cutoff, that ipso facto does not become arbitrary because the cutoff is not operating as a condition of eligibility. If you can demonstrate that the imposition of this cutoff has become arbitrary, for instance, by putting an extraordinarily high cutoff, for instance, I'm just giving an example. Like you put a cutoff of say 90%, in which case only you'll get only 2 candidates. Is that really, that could be one ground. Alternately, where the cutoff is designed to exclude people belonging to a certain category, for instance.
It's normally not so clear, Your Lordship. It's very difficult. One may think many things, but very difficult to actually on paper to establish any of this. So, which is
Therefore, whenever it gets challenged, that's the only way. Arbitrariness, whether exists or not, the test of arbitrariness has to be seen. So therefore, we can give that leeway to the state to modulate it depending upon how the exam works out. And if somebody challenges it, he has to show that the method adopted is arbitrary. That's the only test by which you can actually see.
This is what we had.
In case to case, the state has to prove whether the change in the rules has created some kind of an arbitrary.
Ideally, Your Lordship, this should be provided for in the rules. That is this, when this.
See, not everything can be provided. That's the difficulty. You know, expecting everything to be provided in rule. You don't know how the exam will turn out to be. You don't know how many will appear. What kind of further requirements are to be made by the state. And if you say that everything will be governed by rule itself, the life situation will defy every time the rule. Or else we'll be bound by a rule and we'll have to suffer the oppression of a rule. So therefore, we'll have to balance it. If the state will prove that it is arbitrary, is unable to establish that it is arbitrary, then in which case court might say, yes, you have introduced a new thing. And
you know, I think the error in para 14 really, with respect, very distinguished judges. I mean, one doesn't want, you know, like to say that there's an error. There's such great judges of that era. But you know, the judgment seems to equate. The minimum marks which were prescribed for the written exam in order to go to the viva voce. It seems to equate that with the minimum marks which are required in the final aggregate of the two. The purpose of one, namely minimum marks in the written exam to go to the viva voce, is to screen out those who have not obtained a minimum from going to the viva voce. It's like a condition. It's like a screening requirement. This requirement that you must get 600 marks in the aggregate is not like a screening requirement. It's really intended to ensure that, you know, people who enter in the service have a certain degree of quality about it. Now you are right. I mean, why can't they do that in the beginning?
Just to add one sentence to what Hari said,
To write in the advertisement.
You are in a way right. You know, you're pushing it.
One way of reconciling, possibly subject to what Lordship say, in this, what the judgment in this Umesh Chandra, what they say is, this minimum marks have been set up, fixed by the selection committee and not by the High Court. If the High Court had done it, maybe Lordship may kindly say the same para.
Para 14?
Para 14, Malad.
Yeah, Haribhai, just read para 14 again.
Yes.
That's because we didn't read that together.
Yes, Your Lordship.
Just read that slowly because that's a key para.
Yes. With regard to the second contention, namely that the High Court had no power to eliminate the names of candidates who had secured less than 600 marks in the aggregate after the viva voce test, reference has to be made to Rules 17 and 18 of the rules, which provide that the selection committee shall call for viva voce test only such candidates who are qualified at the written test as provided in appendix, and that the selection committee shall prepare the list of candidates in order of merit after the viva voce test. There is no power reserved under Rule 18 of the rules for the High Court to fix its own minimum marks in order to include candidates in the final list. It is stated in para 7 of the counter affidavit in writ petition so and so that the selection committee has inherent power to select candidates who according to it are suitable for appointment by prescribing the minimum marks which a candidate should obtain in the aggregate in order to get into the Delhi Judicial Service. It is not necessary to consider in this case whether any other reason such as character, antecedents, physical fitness, which may disqualify a candidate from being appointed to the DJS, may be taken into consideration by the selection committee while preparing the final list. But on going through the rules, we are of the view that no fresh disqualification or bar may be created by the High Court or the selection committee, merely on the basis of the marks obtained at the examination, because clause 6 of the appendix itself has laid down the minimum marks which a candidate should obtain in the written papers or in the aggregate in order to qualify himself to become a member of the judicial service. the prescription of the minimum marks of 600 in the aggregate by the selection committee as an additional requirement which the candidate has to satisfy amounts to an amendment of what is prescribed by clause 6 of the appendix. The question whether a candidate included in the final list prepared and forwarded to the selection committee may be appointed or not is a matter to be considered by the appointing authority. In the instant case, the decision that a candidate should have secured a minimum of 600 marks in the aggregate in order to be included in the final select list is not even taken by the High Court but by the selection committee. Moreover, recruitment of persons other than district judges to the judicial service is required to be made under Article 234 of the Constitution in accordance with the rules made by the governor as provided therein in consultation with the High Court. Article 235, which vests in the High Court the control over the district courts and subordinate courts thereto, cannot include the power of making rules with regard to recruitment of persons other than district judges to the judicial service as it has been expressly dealt with in Article 234 of the Constitution. We are of the view that the selection committee has no power to prescribe the minimum marks which a candidate should obtain in the aggregate, different from the minimum already prescribed in the rules in its appendix. We are therefore of the view that the exclusion of the names of certain candidates who had not secured 600 marks in the aggregate, including marks obtained at the Viva Voce test from the list prepared under Rule 18, is not legal. We therefore quash the list prepared by the selection committee and direct that a fresh list shall be prepared in order of merit on the basis of the aggregate of the marks obtained by the candidates at the written examination and at the Viva Voce test, without taking into consideration the moderation of marks added by the High Court and without reference to the decision of the selection committee that candidates who had obtained less than 600 marks in the aggregate.
मारवा और उमेश चंद्र में कॉन्फ्लिक्ट लगता है.
Please.
Again said that, the 600 marks requirement was introduced by the selection committee and not by the High Court. In fact, just
234 High Court, so that is one way maybe you can reconcile this, saying that in that context this was said, not in the context of selection committee, High Court maybe could have done.
yes.
No, actually, earlier they also say actually there's a contradiction that there's no power reserved under Rule 18 for the High Court.
What is the main thing?
They say even the High Court couldn't have done it.
Done it.
But then they say in any case, the selection committee had no power.
No power.
Yes, Ms. Natraj? Yes, Ms. Natraj?
All these judgments, there is no conflict at all in any of the judgments. The very reference itself was in the context, it was wholly unnecessary. Let me point out first from Marwa, that is two judges judgment. Marwa, that's the 1974.
Yes.
Whereunder they said that after selection is over, only the benchmark was fixed. For example, last about 20 candidates have been selected or the eligible, found eligible. They said that top 10 or 20 creep we will select. That's all, that's only for the purpose of appointment. That was an issue in Marwa. They said that 20 candidates have qualified, but however, those who have secured top above 55% or 60% only will appoint because the person has no indefeasible right to be appointed. In that context, they said that you can't do it.
That is Marwa.
That is
Yes, that was an issue in Marwa. When it comes to
Umesh Chandra.
Manjushri, there was an issue was
Why didn't you
totally
come
different.
to Umesh Chandra first? Because
Yes,
Umesh Chandra.
Umesh Chandra, the court specifically found it's contrary to rules. Kindly see that. It was contrary to rules. That was the finding. On that context, they struck down. Kindly go to para 14.
There is
First,
no
kindly go
power
to-
to such prescription is what he says.
Please.
He's saying there is no such power to do it.
Yes, no such power. Contrary to rules. That's what they found and they struck down. Kindly go to, first kindly go to page 735, that para 13. Then para 14.
They say there is no power reserved in Rule 18
Yes.
of the rules of the High Court to fix its own minimum marks in order to include candidates in the
Correct.
final list.
Correct.
But do you require that power?
Yes.
Even in
Yes.
In Marwa, there was no power.
Yes. There was
Marwa, there was no power expressly.
No, in the Marwa, that was only, they fixed the benchmark, the upper limit. By
Here also, that's what they did.
No, here they have done something else. Kindly see.
Here what they did
Yes.
was,
No,
in the final list
Yes.
of successful candidates,
Yes.
they said anybody below 600 marks in the aggregate, we are going to knock off.
That's, yes, they changed by the time, because contrary to rules, they changed it. Kindly turn to page number 735, that
That
para
was no
30.
express rule.
Yeah, contrary to rules.
No. They call it contrary to rule, but the point is that the rule didn't say that you will not do this. The rule said
Yes.
that you must get 60% in the aggregate in the written exam to go to the viva voce.
Correct.
That was the only thing that the rule said.
Correct.
They said that implicitly, therefore, this
Yes.
is the only requirement which you can impose.
That's right.
Of the minimum marks in the written exam
That's right.
to go to the viva voce.
That's right.
You cannot, after the viva voce, they said, have another requirement that you must have
Correct.
at least so many marks.
Correct. But they changed there. But where under Marwa, what they have done is, there are about top 20 candidates have been qualified in the all this one, both viva voce and the written examination. But they fixed the benchmark for the purpose of appointment.
Here also.
Yes.
Here also.
No, here what they have done is, they have changed the rules here.
No.
They went beyond the rules.
No.
Yes, kindly see the facts
Marwa
also.
De facto, this is de jure. Marwaha, without coming up with the rule, they've done the same thing they can't do. So if the law is that I can't increase the criteria, then I can't do it indirectly by not
No.
directly increasing the criteria, but very conveniently just appointing the top 5 and omitting the bottom 15.
Mr.
Yes.
Natraj,
Yes.
our problem is that if we say that as it appears,
Yes.
that Marwa and Umesh Chandra are on the same footing, basically, the
Yes.
fact situation is on the same footing,
Yes.
then by Manjushri, by affirming Umesh,
Yes.
implicitly therefore overrules Marwa. We are in a constitution bench, we still have to consider Manjushri.
Yes.
We are not bound by either of them.
They may have referred to that.
That is, Sankarshan Das. That is where the Marwa and all line of judgments was considered and it was approved. Lordship would say that paragraph 7 of that. So the reasoning given in the Marwa that once you don't have an indefeasible right, so I can select from the list. Those until that list is not disturbed and I have a right to take whoever I want to. There are methods then prescribed. I could take top 5 or could put a qualifying marks for the selection.
So Sankarshan thus expressly affirms Marwa?
Yes, it notes that. The Lordship may have volume 4.
Let's see that. For the compilation. Very first case. सारे ने मेहनत किया है अभी तक।
Lordship may have page. That's the first judgment of volume 4. Volume 4. So the Mr. Hansaria's. Yes, sir. This is post Umesh Chand Shukla. Lordship, see paragraph 1. This Constitution Bench judgment, 1991. The Umesh Chand Shukla's judgment is 85.
It's compilation volume 4. Madam. The compilation
I was
volume,
reading the volume 4,
compilation volume 4, first judgment.
paragraph 1 notes Marwa. No, Umesh Chandra is not referred. No, not referred. Yes, Your Lordship.
Lord, Marwa is affirmed only in the context of there is no indivisible right to be appointed. That is, that
right.
context Marwa is affirmed, not on this issue. Yes, madam. So,
So in a different context, the Maro was decided.
Whether persons who are there in a select list would have a right or
Right,
not.
correct.
They have held that once you are there in the select list, that doesn't mean that you have a automatic right to be
That is
appointed.
where-
Para 7, huh?
That paragraph, that is where Your Lordship will have to see at that stage whether if prescription of either a qualifying marks to select a out of that list would then be impinging this principle or not, because then
No, not to have a right is one thing. But whether the state has acted arbitrarily or to
That's a
execute something is a different thing.
yes, that's a different thing.
This is in para 7. If I
Para 7 of Shankarshan, huh?
Yes.
It is not correct to say that if a number of vacancies are notified for appointment and adequate number of candidates are found fit, the successful candidates acquire an indefeasible right to be appointed, which cannot be legitimately denied. Ordinarily, the notification merely amounts to an invitation to qualified candidates to apply for recruitment, and on their selection, they do not acquire any right to the post. Unless the relevant recruitment rules so indicate, the state is under no obligation to fill up all the or any of the vacancies. However, it does not mean that the state has a license of acting in an arbitrary manner.
Yes.
The decision not to fill up the vacancies has to be taken
That's a
bona
test.
fide
Where they all these
appropriate
cases
reasons.
balance it, no?
And thereafter,
Right.
this, in fact,
It says that there is no right, that does not mean that the state can act
Act
arbitrarily.
Yes, that's
So
right.
therefore, it takes us to a
So-
situation where, yeah.
You cannot breach the merit list. You can't take a candidate at serial number 20 and
Yes.
ignore a candidate at serial number 1. But equally, when you say that there is no indefeasible right to be selected once you are in the select list of candidates or merit list of candidates, that really means that the state is not bound to fill up the entirety of the select list corresponding to the number of vacancies which you have advertised. You may still stop short. Now, how do you stop short? You will apply a cutoff. Then that cutoff will be on the basis of marks.
So it is that cutoff is under scrutiny.
Right.
Whether a cutoff in case to case has to be seen.
Whether it is
and
arbitrary.
considered, that's the test.
That's a
the
test.
only
That's a
That's the
test.
test.
That's an absolute
And
test.
when we test whether it is arbitrary or not, what is the reason that prompted?
Yes,
Suppose
what
it is for the betterment, having the better qualified or better quality material come into the system. That is a bona fide,
if it is.
may I just respond, my lord? Like in the Kerala case, the introduction of a cutoff resulted in a person with a lower aggregate coming up and a higher aggregate coming down.
It was disturbed.
Test of arbitrariness, that could be one test. Whereas in Marwa and all that doesn't happen.
That doesn't happen.
Whatever happens, the person with a mark 10 will not get selected over a person with mark 4. So then that could be a test to say there's no arbitrariness. Like to respond to what Lordship said. So in either in Marwa or in Marwa, what weight with the court was selecting that 55% will not result in a lower mark person coming in front. Whereas in the Kerala case, as a result of the introduction of only for Viva, the person with 5 marks got it, person with 10 marks stayed out. So that was arbitrary, like your Lordship's held yesterday. So, and if I may say so, my Lord, I'm trying to reconcile Marwa and Umesh Chandra. In Marwa, the rule said 45% you can be appointed, nothing else. So 45%, there were 40 people, 15 vacancies were there. State said we'll take only, but then they already were in the select list and state said we'll take only 7 and not 15. That was the grievance. In that context, they said 55 can be done. There's no right to be appointed, etc. Whereas in this case, Umesh Chandra Mishra's case, they have not got into the select list. There is a written exam, there is a Viva. Now, after that, before getting into the select list, they prescribed a 600 mark cutoff. So the court said, no, because you're not in the select list, yes, you cannot create this distinction before letting a person in the select list. So I'm just trying to reconcile. That could be one way to reconcile. I'm just thinking, I may be wrong. I'm just putting it for your Lordship. That could be one way of reconciling Marwa versus Umesh Chandra Mishra. There is no conflict per se. In one, it was a select list they've gotten. In this barrier was created just before entering the select list. Therefore, so there is no
Are you
conflict.
trying to say every barrier that is created?
Yes, my
So
lord.
whatever may be, assuming that there is a public purpose involved,
Yes,
because giving a kind of a weightage to interview is equally important, then what? Then it will become arbitrary, is it?
Yes, Lordship,
So
because
that's the,
you are,
if you are approving the first part of it
Yes,
in Marwa, in the later part of it, when you are creating a barrier by increasing a cutoff mark for interview,
yes, my lord.
that by itself can become wrong.
No,
yes,
that,
Lordship. Then you should continue the next year also, but you are not doing that. You are again coming back, no, Lordship.
Because
What-
there are,
what
there are
they-
several line of cases where cutoff marks, even in the written examination, has been prescribed later. Only Viva was there, they prescribed the minimum. Lordships have approved those line of judgments also. And then I just cite one judgment, actually that marries both Marwa and Manjushri in a very righteous way, if a Lordship could see that. That's a later judgment of Yogesh Yadav. And that actually says, in fact, there were 3 stages. One was a stage of written examination. There was a minimum qualifying marks. Thereafter, the select list was prepared. After the select list was prepared, they further provided for a qualifying marks. This court approved it by saying that Marwa line of cases and the Manjushri stand on a different footing. Marwa says later you can definitely prescribe, because obviously the same line of indefeasible right, etc., would not apply in that situation. In fact, if you then like to look at it, it would be like Umesh and Shukla would come in the way. But that is how it has been. I'll just read para 13 of that.
Prescription is never a problem if you do it in advance.
Yes.
The problem is that without specifying,
it's evolved as a
when people don't know about it, in the last moment, they
Yes.
apply a principle.
Yes.
That principle, if it is applicable, if made applicable by virtue of an existing rule, there is no difficulty.
Yes.
It is application of it, which people get to know only through the RTI. That's where it's,
If I may,
and also it contributes to uncertainty.
if I may just submit to your lordship, just 2 things. Lordship, as far as there are 2 aspects, your lordship. Interview, I think, is a Lordship, as far as interview is concerned, your lord. As far as interview is concerned, your lordship, our submission is slightly different. That is, there's even a 3 judges judgment which is held that there can't be a cutoff mark for the interview because Shetty Commission recommendation has been endorsed in all India judges. So that's a separate issue where quite a few cases, including that Gujarat case, etc., they are going to definitely fight it out. But as far as these are all concerning exams. This Umesh Chandra, Umesh Chandra and Tej Prakash and Marwaha. So if one were to limit ourselves to examination, the only request is, while your lordship says that yes, we cannot preclude an enhancement in standards subsequently, what your lordships can possibly also lay down is that if there is a need subsequently to enhance a standard, reasons should be given in such an order passed by them enhancing it, so that tomorrow it becomes something which can be judicially reviewed. There are some criteria. Otherwise, if no reason is given about why this change is happening at
That's the point. That also is there.
And the stage.
In case we.
It gives us a method to challenge it. Otherwise, it's very arbitrary and it's very difficult to pin them down to any reason.
No, there is a higher principle also. Apart from reasoning, if you are speaking on the principle of certainty,
yes,
then there must be an existence of a rule.
Yes.
In advance.
Yes.
So you would know how to handle it depending on the large number of applicants, less number of seats. Then the rule provides a kind of a choice for the state to adopt or prescribe.
Yes.
So then if it is prescribed in the rule, perhaps they will be able to
some sanctity.
Like in this, he said, where is the power you have? You don't have the power is what Venkatramaya has said.
And my lord, to just between Tej Prakash and Marwa, if I may submit, my lord, according to me, my lord, there is no conflict. para 12 of Tej Prakash proceeds on the assumption, Lordship may kindly note para 12, says Manjushri holds that if there is no minimum marks, there are 15 vacancies and suppose there are no minimum marks, the person with the lowest 15% should be taken. Manjushri never says
Never said that.
So to that, the reason why it said there is a conflict is Manjushri para 12, Tej Prakash goes on the assumption that Manjushri says that, whereas Manjushri doesn't say that.
No, just Chanmeshwar doesn't say that Manjushri says that. What he says is that the consequence of Manjushri would be that everybody would be entitled to get appointment, whatever the marks and however low their marks.
My response to that would
That
be
is not so.
Yes,
That is not
my
so.
response would be
So you
that.
can always say that we are not going to take everybody.
So that is correct. That is
Really, because there's no benchmark doesn't mean we'll take somebody who has aggregated, say, 42 marks.
Directly, Sankarshan Das.
Yes,
Is an answer
yes.
to.
That was
that
never the
observation.
intention of Manjushri. Manjushri's only concern was, like a lordship said, you cannot introduce this surprise cutoffs suddenly in the middle of a process. That was the intention of Manjushri, like happened in Kerala, irrespective of the rule. So that was the intention of Manjushri, nothing more. So there is no conflict per se between the two.
You know, but since we are going to lay down the law and we are going to answer the reference in this case,
Yes.
we'd like to look at all the authorities, because you know it shouldn't be that the constitution may miss some authority, because whatever you want to cite on both sides.
Yes.
Because we've now seen Manjushri, we have seen Marwa, and we've seen Umesh Chandra and Shankarshan Das.
Yes.
But let's see the entire, so that we get the full nuances of the area actually there.
The test would
So
be.
now that we have done away with the many of those matters, we are actually left with the essence of the issue.
Yes.
So therefore, we will focus only on the principle which needs to be
The
discussed.
test would be the crystallization of rights.
Yes.
Crystallization of rights. At what stage they have introduced, that would be the crucial test.
That is the
When there are
important point
multiple
to be
stages of examination, selection process.
Process is also, Mr. Nataraj,
Yes.
it's not just a crystallization, the process itself.
Yes, in the process,
Fair.
yes, the process, there are multiple stages of selection. Let us take, first there is only the first preliminary rounds. First only the written examination. Then thereafter, those who have qualified for the next test, the rules can be notified even later. The crystallization of right is only go to the next stage, not to get finally selected. So the crystallization of right would be the crucial test, number one.
No, but if we take that, that will be extremely rigid, because what will happen is the actual crystallization is right is only when a letter of appointment is issued in a broader sense.
That's, yes.
Up to then, you have only an expectation to be considered for appointment. But the consideration process also has to be fair with the state of the public.
You can exclude people.
But go to the very next stage, when multiple stages, the selection is to be made in multiple stages. To go to the very next stage, first he should know what are the limitations, what are the rules, the regulations governing in that stage. Then when he qualifies for the next stage, then before he starts with that process, he can be made known. Not necessary that entire process should be notified in the beginning. So therefore, crystallization of rights in each stage, that would be the crucial stage, test number one. Number two, whether it has been uniformly applied or not to everyone, that would be the second one. Third one, whether there are mala-fides. These are the three tests which will have to be passed.
Lordship, may I just add one point with my Lordship's permission? Going on from the crystallization aspect, my Lordship, here the issue with reference to what has happened in Kerala, my Lordship, is a very yesterday. Now, 11 of those petitioners, my Lordship, we have actually struck down, my Lordship has struck down as unlawful. The fact that the notifications come in, that has been struck down. Now, 11 people, my Lordship, who were at the first stage eligible when the written examination was given, and subsequently the suitability test when it comes to the Viva. Now, these 11 people, my Lordship, the issue again goes back to this. Marwa states at the end of the day that there's no indefeasible right to have a right when it comes to your appointment process. Now, here, my Lordship, you're borrowing from what the AG has also stated. The crystallization of the right in most cases, the challenge is this, my Lordship, because at the first stage, when the rights are not crystallized, what happens is the process goes on and other people enter the fray. Now, what happens here is that the entire process doesn't get stayed, my Lordship. What happens is the process for a certain group of people who are eligible, otherwise maybe not suitable, they are stopped. Meanwhile, what you have is a parallel track on which the other candidates start to move along. Now, here, my Lordship has seen 8 years has gone by. In Guwahati, it was 2011. Now, my Lordship will see that the challenge for most people is the remedy. Now, here, my Lordship, when you have to go to your very own High Court, where the selection committee has already ruled in your favor or against you, you go there to the same people who are going to judge your case. What happens inevitably, Article 32 is resorted by all of us. So we come in Article 32 to my Lordship here. Meanwhile, we are without no remedy. We lie remediless, then the process is already taken over. Now, what happens there, my lordship?
Have interfered against the selection committee of that very High Court.
My lordship is right. My only point here is this, my lordship. What happens is, I understand after listening to all that has been going on, the challenge, however, remains here, my lordship. People who are capable, people who are otherwise absolutely qualified, those people, my lordship, fall on the wayside. Now, here the challenge is, my lordship, in Assam, in Rajasthan, in Bihar, in Kerala, in Manipur, we have seen that what is happening is, at the end of the day, the rules have actually changed and there's no level playing field. The least that we need to do is lay down a level playing field to the extent that the rules of the game, at least when it comes to that bare minimum, where the real issue, my lordship, is between the Viva and the written exam. Now, Viva, my lordship, we all understand that Viva is important for suitability. I'm sorry, my lordship. For suitability, my lordship, eligibility, my lordship is right. Written examination gives you the basic qualifications to understand whether a person is eligible. Now, my lordship may talk to people, talk to candidates and feel that perhaps suitability is not there. Maybe the person is not suitable for that role. And rightly so. There could be multiple factors for that. But the key challenge here, my lordship, is where is the remedy and how do we fix the remedy unless and until the statutory rules are tightened? Because the statute in Kerala, my lordship, saw yesterday, the Rule 3C, subclause 3, that one actually laid down clarity, very clearly a stable legal system with rules which are absolutely certain. It was not inchoate. It was not inchoate. The rules are clear. At that particular stage, the Kerala High Court went ahead and disaggregated what was already aggregated. So you have an aggregate of the interview, you have an aggregate of the written examination, and then you have the cumulative marks in front of you. But thereafter, what happened is there's a disaggregation which happens. Now, then the rules don't become immutable. They are mutable, they're divisible. Now, when you divide the rules, then essentially the system will collapse. Now, the rules of the game, my lordship, when we say...
Kerala, what they did was they introduced a minimum cutoff in the Viva Voce after the Viva Voce was there.
That's true, my lordship.
And the consequence of that, as we said, was that you are going to virtually put out of competition those people who don't score the minimum cutoff on a yardstick which was never notified earlier.
Absolutely. My lordship.
That's why we felt that, that was arbitrary, because this was not something which was done subsequently merely to cut down the number of people we are going to get finally, or to define quality in terms of the best candidates. But what you are doing was that some of your best candidates on the overall aggregate would be knocked out only because they didn't get the minimum marks in the
My lordship, any
Viva.
authority, my lordship is right. A certain fair play at the joints, my lordship, anybody who even recruits a driver will understand that you need fair play at the joints.
It works out to be is a principle where the rules on the basis of which the selection process will be undertaken must be notified fully in advance.
Absolutely.
And your argument is working out to be saying that no discretion must be left any time after the notification which has been issued. So once at the time of the notification, you must say what percentage will be there and at what stage you will apply a cutoff. Everything must be a prescription of rules. And if it is not provided in the rules, then there shall not be a power till the final order is made.
Yes.
That is what perhaps troubled Chalmeshwar in referring to, because there may be intervening public interests which would require the court to get into the appointing authority to have certain modulations in between. So that is actually a balance between these two.
My lordship here.
But the drift of Justice Chalmeshwar's referring order indicates that he has tilted more towards Marwa than towards Manjushri. Clearly.
My lordship.
He was saying that public interest perhaps requires it, of course, on an understanding that
subject to Article 14. And second, he said that, well, what is essentially a matter of procedure can always be introduced later, subject to 14.
My lordship may only add one more point to what fell from Justice Narasimha and my lordship as well. My lordship, at the end of the day, should the consequences of the same be oppressive? My lordship, Justice Narasimha had said that oppression at the end of the day. Now, what happens here is, my lordship, these people today, 11 petitioners, my lordship, what has happened is for no fault. So what is happening is the process is correct, procedurally it is regular, or there is some kind of a system where, my lordship, what then happens is the resultant consequence of these things become so absolutely unjust, unfair, and oppressive that it vitiates the entire atmosphere as well as right. Fairness is concerned, my lordship said the arbitrariness test becomes important here because there is also a certain level of accrued legitimate expectation.
Notes.
My lords, on the question of Tej Prakash, my lords. My lords, before my lords,
Have you concluded or you still have to argue something?
Lordship, it is like if the person, he is not knowing about his own conditions, that in what conditions he has to appear for the examination. Because here there is no viva voce, there is no interview, there is nothing, there is only one exam of test of language. And which test of language when he has not even told the minimum marks. It is hurting his own rights. In Article 14 is really infected because, Lordship, he had no knowledge about it, that what is going to be, because he had to just clear the exam. That was the knowledge.
And in your case, they introduced the bar of 75%, no?
Lordship, suddenly at the time of just result when had to be declared, it was told that you had now the 75% is cut. There was not even a minimum. It was only that you have to pass this language test, which there is no minimum, no maximum, just pass it, and then you are in the for the promotion. This
Then
is
they
not
put the 75%.
and they were in-service employees, not even that, and then it is not even continued. Next year they come to know that if we keep it so high, they are not going to get any of the employees in the services. So they again came back to the same condition.
All right, do you have anything else to cite or now that's done? You're done?
Yeah.
My lords, may I mention, Your Lordship, kindly, may I take at least, I take only, no, my lords, I'll take only 2 minutes, my lords. I won't take more than that. Your Lordship, may kindly see Tej Prakash for a moment. In fact, so far as answer to this reference probably lies in Tej Prakash itself. That's my submission, my lords. There is no occasion. Your Lordship, may kindly come to page 50. Your Lordship,
We are not concluding today
True,
because, it's, we are hearing the reference now. So once we are hearing the reference, we would like to be, once you are deciding a case on principle, we'd like to hear you and, maybe you can all reflect on what we have been,
Yes, my
what we've been asked.
So since my lords,
So Dr. Bhardwaj is now over.
No, Lordship, because two of the paragraphs, no, Lordship, point for
Great. I thought with a sense of satisfaction, you said, yes, you've heard me out and now I'm done.
Once we said that we are not concluding, your new ideas.
I am the main, who are the sufferer. I cannot be quiet, Lordship. There
Yeah.
are two of the paras of the same my judgment.
What will happen to your Rajasthan State Road Transport Corporation if you only argue, now in the Constitution bench?
Sir, that is there, sir, but Lordship, this is more important. What I'm saying, Lordship, two of the paras, they are speaking very clearly that what exactly had to be, what was not followed, and they have, in their own judgment, he has passed those orders, and I will like to read, Lordship, the reference judgment.
Now we've read the reference judgment. Reference judgment is only a guide for us. It's not a precedent. It's only a reason why they have referred it.
It's not his own points of how it is favoring it. It is not all the time against, Lordship. When it talks about the Manjushri, although it is talking about Marwa, but it is very contradictory. Marwa has nothing to do with my case. It is totally different.
All right, we'll conclude on Tuesday.
What you could do is,
Tuesday ko le lete, because
as Honorable Chief Justice has
not
told
going to
you,
be-
formulate on the basis of what discussion that has happened as to how should be the ideal principles that would be followed only for the purpose of precedent. Because facts are over. Now there are no facts, no cases
You have
remaining.
given us your written submissions. Now, apropos what has been argued in the court, you can fine tune your submissions just down to 2 pages or so, just the key. And suppose, we were inclined to give the administration some free play in the joints. What should be the safeguards? And to what extent can they impose a requirement after the process has begun, and which are those requirements which are permissible, which are requirements which are impermissible after the process has begun.
Those things.
You cannot, for instance, to my mind, one clear distinction is conditions of eligibility. You cannot introduce new conditions of eligibility after the process has begun. Then if you cannot introduce or impose conditions of eligibility, you can certainly do shortlisting. All right, if you have a large number of applications, can you not provide for shortlisting? Or is it that you must also, the notification must provide that we will do shortlisting? In the absence of the notification originally providing that you will do shortlisting, does the employer not have the innate capacity to do shortlisting? And finally, when you're preparing the select list of candidates who will be recommended for appointment, can the employer not say, subject to an Article 14 challenge, that we will apply this yardstick to ensure that candidates having a requisite quality are recruited? That must have the bearing on the nature of the service. You can't apply the same yardstick for recruiting upper division clerks without meaning anything pejorative as to appointing judges.
Yes.
When you're appointing a UDC, you can't say, well, we want to have the best, we want to have the superlative quality. Certainly when you are recruiting even a translator, because it's a very specialized task. When you are recruiting judges, either at the lowest judicial service, the civil judge unit division, more so at the district judge level, which have been a lot of these cases that we have come across.
My Lord Chinnappa Reddy exactly said in the case of Leeladhar, which has been cited before this honorable court, that university admission, different yardsticks are to be used. The judgment is already before my Lord.
So what we'd like you to do now is that, we have looked at four of the basic, we have seen the four basic judgments. Please make sure that we don't miss out anything.
Yes.
And you can give us in chronological order, which are the judgments which you have to look at. And I hope all of them are on in the compilation.
There are also few additional judgments which are not on record, which are there in my written submission.
If you can collate with.
I'll do that.
Two page.
Yes, Your Lordship.
Brother Rishikesh Roy had something to tell you.
Yes.
No, you wanted to marry two judgments.
My learned brother whispered to me that you wanted to marry Manjushri with Marwa. So he was telling me, brother Rishikesh tried to, sort of make it a little less obvious. So which is that marriage judgment that you wanted to cite? Please send.
Actually, there's a divorce there.
Put it in your note.
Divorce.
What is that citation?
Yogesh Yadav.
Yogesh Yadav, no?
Yogesh Yadav. What is that?
2013, Yogesh SEC 620.
13?
2013,
14 SEC.
volume 14 SEC 620.
623.
There in the.
Yes.
620.
623.
620.
There are 4 volumes filed with Aksaria, which has most of these judgments. There is some additional.
Volume 4.
Volume 2.
So now, how long would you take, Dr. Bhardwaj? You are now done.
Volume 2, Your Lord.
Another half
Ten-
an hour.
No, take 10 minutes or 15 minutes, not 10 minutes or so. And then whoever is following, Harpriya, you will follow now? 15 minutes. But between all of you, do make sure that you do focus on those judgments of the principle and the para, that's all.
Submissions had already given these safeguards,
Right.
assuming that such an eventuality may arise. I've added some safeguards, but I'll further fine tune it and put it to 2 pages.
Because Harpriya, you're right, we must answer the reference because, otherwise the judge and 3 judge benches will be again left with the same problem.
Yes, sir.
Because lawyers will argue all the same thing that, look, Umesh Chandra has been
Certainly.
approved in Manjushri, but Umesh Chandra is contrary to Marwa. Therefore, Marwa is implicitly overruled. We must put an end to it.
And this reference was 2013. I also, because of this reference only, my Lord, I was struck.
Ideally, we could have answered this in one of the judicial service matters, but the issue didn't arise here. We have tacitly dealt with it in the Kerala matter, but again, there it was,
Malaj, in fact, we have dealt with this issue about selection process very clearly in the judgment passed by my lordship in state of Jammu and Kashmir.
In state, I've dealt with it.
My lords, if I may be just allowed to read 2 lines, my lords. It says the qualification and other eligibility criteria for such posts should be explicitly provided, and the schedule of recruitment process should be published with certainty and clarity. Thereafter, my lords, hold that the advertisement should also specify the rules under which selection is to be made, and in the absence of the rules, the procedure under which the selection is likely to be undertaken. This is necessary to prevent arbitrariness and to avoid change of the criteria of selection after the selection process has commenced, thereby unjustly benefiting someone at the cost of others. So my lords have held it. You're right, my lords have to maybe lay down the inviolable principles need to be laid down so that hereafter the human conduct is regulated.
Just cite that judgment
Yes,
also
my
on
lords,
Monday.
there.
So can we add something on the bias issue, my lords? My lords, how the interview should be conducted in an ideal interview?
In 502, who is a 502 is a motor vehicle matter. 502, if you could email the submission, because we have only submissions of Mr. Tushar Mehta. So 502, if you can give us the submission by Sunday evening, if you email them to the court master, then we have the submissions on record. So Tuesday, this matter will conclude, and then we'll go on to the next matter on immediately after we have started this.